I'll screw up.
All right. Good morning.
Hi. Good morning, Your Honor.
Here is.
Okay.
If you'd like, I could also just handle everything on Zoom for you as well. Promoting people.
Would you please? Thank you.
I'll be ready to start the record once I change that.
Just let me know when we're ready.
I will.
Hey,
Morning. Oh, this is the reset for tomorrow? No. The father and the son. I just need to sign that one. You can do it yourself. Okay. I thought I released him in the custody of the father. No? No, this Brian is correct. That was the first one. The officer had my stamp. You'll write for me?
That's right. That's why you do that. I only have 6.
All right. Jenny Heredia. Oh, okay.
All right.
Todo el mundo de pie.
All rise.
Todos de pie.
All rise.
Todos de pie.
Raise your right hands, please.
Levanten la mano derecha, por favor.
Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Please say I do.
Bueno, prometen que el testimonio que van a presentar va a ser la verdad, solamente la verdad. ¿Será así? Digan que sí.
Go to the bathroom. Go close the door. Everybody raise your right hand.
Todo el mundo levante la mano derecha.
Wait a minute again.
About to give is the truth, the whole truth, and nothing but the truth.
Uno, prometen que el testimonio que van a presentar va a ser la verdad, solamente la verdad.
I do.
All right. Jenny Heredia. Jenny Heredia.
Oh, she's coming. Good morning, Your Honor. Assistant State Attorney Cameron Smoller on behalf of the state.
Morning.
Good morning, Your Honor. APD Brian Arnold.
And good morning, Your Honor. ASA Roberto Asensio again for the state.
Good morning, Ms. Heredia. You're charged with battery. The court finds probable cause. State with your position as to the bond in custody.
Your Honor, the state requests $1,000 in the stay away order.
Defense.
Your Honor, I have the first female on the schedule as Miss Oliver Tania.
No, it's the BB.
Okay.
The BB.
Yeah.
I don't even.
Sorry, Your Honor. I was on the wrong calendar. Your Honor, we'd be requesting pretrial services for Miss Heredia. She has no priors.
He doesn't address from Orange Blossom Trail, Orlando. Does she qualify?
No, she's only staying here for 4 days.
She doesn't qualify, so I'm gonna find probable cause, set bond at $1,000. Order a stay away order.
Okay, Your Honor. Noted.
Oh, wait. Does Ms. Heredia speak English?
Yes, sir.
Okay, Ms. Heredia, I'm gonna order you to stay away from Sonia Segar. You're to have no contact with her at all. If you violate this order, you could be subject to rearrest. You cannot possess a firearm or ammunitions, and you have to stay away from her.
County, she doesn't qualify for PTS.
She does not qualify.
Oh,
Okay, do you understand?
I have an address here.
Is your permanent address?
Yeah, it's just I'm
Back to the property without being accompanied by a police officer.
I understand that, but I have a permanent address here. It's just that
Madam. Your Honor, if she can provide a Miami-Dade address, would you consider PTS?
For 4 days. We do not take people that only live here for 4 days. They have to live in Miami. for 4
Corrections
days.
is saying no. So the answer would be no.
Understood, Your Honor.
You have to tell me that I did everything correctly or not.
Sure.
Judge, what was the disposition for her?
Okay. They're all applicable. Initial.
Straight bond 1,000.
Joanna Dela Cruz. Morning, Ms. Dela Cruz, you're charged with battery. Let me review the arrest affidavit. Right, the court finds that there's probable cause for the battery charge. What is the state's position?
Your Honor, the defendant has no local priors. The state requests $1,000 in the stay away order.
Defense?
Your Honor, she has a Miami-Dade address with no priors. We'd be requesting pretrial services for Ms. Dela Cruz.
Okay, I'll order pretrial services. Alternate bond is $1,000. I'm gonna enter a stay away order. One moment. From Kevin Wilson. Ms. Dela Cruz, pursuant to the stay away order, you're not to possess any firearms, weapons, or ammunition. You are prohibited from coming in contact with Mr. Kevin Wilson. And you only may return to Mr. Wilson's residence if accompanied by a police officer. You're not allowed to have any contact with him. Thank you.
Yeah, good.
Daniel Hamilton.
Reset for tomorrow. He's in Ward D.
Tomorrow is what? 3/9. Anthony Smith. I didn't sign it.
Oh,
I haven't gotten in the groove yet. The docket
This is
entry.
Show you. Just put the things.
I'll get it.
This is
Okay.
all on the first page of the A form.
Okay, Mr. Anthony, you're charged with battery. Let me review the arrest affidavit. Are there any priors?
Your Honor. Yes, there are a number of priors. I don't know if you want me to go through them all. They're all remote in time priors. I will ask you to take judicial notice of the F91 in specific.
1991.
Yes,
What was that about?
that was a kidnapping, PBL. It was all counts for no action.
But anything since then?
Since 1991, yes, but in 2000.
What was that?
There's a battery of a law enforcement officer convicted with credit time served, 2 counts of that. Resisting officer without violence, convicted with credit time served. Flee and elude, convicted and sentenced. Obstruction of justice, convicted with credit time served. And then there's another F2000 for strong arm robbery that was null pros. A burglary, assault, battery that was null pros. There's also There's also
You have to explain what that means to me. I'm a civil,
yes,
and he does not qualify for it.
no.
Okay, what is the state's position? The court finds there's probable cause for the battery charge. Mr. Smith, what is the state's position on bond?
The state requests $2,000 in GPS level 3 and a stay away order.
Defense?
Defense would be requesting pretrial services for Mr. Smith. The list,
Record. That's what corrections told me.
the cases were no prost, and the most recent conviction was over 2 decades prior. Corrections,
Domestic violence crimes, you can take arrests and dismiss cases into account when determining bond.
Okay, I'm
Even
gonna
if
bond $1,000 with the bracelet. I'm also gonna enter a stay away order. Mr. Smith, you have to have no contact with Zakia Greer. You're not to possess any weapons or ammunitions, and you cannot return to the victim's residence unless accompanied by a police officer. You have to explain to me the difference. I'm sorry. Yes.
Judge, so it'll be 1,000 plus GPS?
2,000, and a GPS bracelet.
2,000 plus GPS.
Giovani Artiaga. Sir, you're charged with battery. Let me review the allegations. The victim is his father. Is that what I'm reading?
Yes, Your Honor.
All right, the court finds probable cause. What's the state's position on bond?
Your Honor, the defendant has priors M24 for battery that was no action, another M24 for domestic violence battery that was no action, M22 battery that was no action, M19 battery that was null pros, M18 for trespassing. The disposition was a withhold of adjudication with a fine, as well as petty theft that was null pros, F18 burglary of an unoccupied structure. That was transferred to, that F18 became the M18. Another M18 for battery that was null pros, and cannabis possession that was null pros. M16 battery, no action. F15 burglary of an occupied structure, no action. And an M21 battery, null pros, and the remaining priors are remote in time. The state would be requesting $2,000 and GPS level 2. With curfew and a stay away order.
Defense?
Your Honor, again, no prior convictions. These are arrests, and then after judicial review, they are null prost. We would request that at the very least he be granted pretrial services.
He doesn't qualify because it's hard.
Your Honor, I will also note that in those priors, it does involve these family members as well.
Yeah, so for purposes of domestic violence, the court can consider the prior arrest history. I'm gonna set the bond at $2,000. I'm gonna order a GPS bracelet. Oh, okay.
Level 2 is what I requested.
Level 2 is gonna be, he has to request permission from his lawyer. He needs to go from his officer. He goes to his house. Level 3 is on.
All right. I'm gonna do level 2 on the GPS bracelet. And Mr. Artiaga, for the time being, there's a stay away order in place from your father, Avelio Artiaga. You are to have no contact with him. If you bond out, you're not to have any weapons or ammunition. If you go to the residence to get your belongings, you must be accompanied by a police officer. I need to write level 3. Yes, level. Okay. Ariel Estrada Miro. Mr. Estrada Miro, you are charged with stalking and criminal mischief. The court will review the arrest affidavit. If the court finds that there is probable cause, what is the state's position on the bond?
Your Honor, the defendant has only a couple priors that are all nonviolent and they're all null pros. The state would be requesting $1,000 in GPS level 1 total lockdown on count 1 and $500 on count 2.
What's the defendant's position?
Again, Your Honor, just for the record, there's no convictions. We understand that Your Honor is taking these into account, the no process and not granting PTS. So we will do the $1,000 with GPS level 2 and the additional $500 bond for the mischief.
So it'd be a total bond of $1,500.
Can I get a breakdown, Judge? It's 2 counts.
I'm sorry, count one, 1,000. Count two, 500.
And no details or?
Hold on, I'm getting there.
Okay. Yeah, me too.
And the bracelet level is what again?
Yeah, the explanation to go into the dog, they have, so we have 3 levels for house arrest.
I'll get it.
Level
Before
1.
tomorrow, I'll get it all.
Level 1 is total lockdown, meaning he can't go anywhere.
No.
Level 2 is gonna be, he has to ask, request, to go anywhere, he needs to go work, school, childcare, grocery. And level 3 is he's able to go anywhere he needs to go without permission. He just ran a break.
But they keep track of where he is.
Correct.
All right, I'm gonna do, the least restrictive is level
3.
level 3. And I'm gonna enter a stay away order. Mr. Estrada Miro, you are to have no contact with Yusnelis Garcia. You're not allowed to possess firearms, weapons, or ammunition. You are only able to return to the victim's residence if you are accompanied by a police officer and if it's only necessary to retrieve some belongings.
Your Honor.
Yes.
We are going to need the services of the Spanish interpreter. He does not understand English well enough to interpret what was said.
Interpreter present.
You told me that before.
Sorry, Your Honor.
Are you ready, Mr. Interpreter, Mr.
I'm ready, Judge.
Okay, this is the one I just did. Good morning, Mr. Estrada Miro. You're charged with stalking and criminal mischief.
Yeah, did you say stalking?
Stalking and criminal.
Got it. Thank you, Judge. Buenos días, señor. Usted enfrenta un cargo por acecho o por acoso, por acecho, y otro por fechoría, daño a propiedad.
The court does find that there's probable cause for these offenses in the arrest.
Este despacho halla que hay motivo fundado para estos delitos, según lo indica el informe del arresto.
I'm going to set the bond for the stalking charge at $1,000 and $500 on the criminal mischief charge.
Para el cargo de acecho voy a fijarle una fianza de $1,000 y $500 para el cargo de daño a propiedad, fechoría.
I'm also going to order that you be monitored with a GPS bracelet level 3.
También le ordeno que tenga un grillete electrónico nivel 3.
And I'm going to enter a stay away order for the alleged victim, Yusnelis Garcia.
Y también le presento una orden de alejamiento que le impide acercarse a la presunta víctima, Yusnelis García.
I have no contact with Yusnelis Garcia. You cannot return to the victim's residence unless accompanied by a police officer and only if necessary to retrieve your belongings.
No podrá contactar de ninguna manera a Yusnelis García y podrá regresar solamente acompañado de un policía y nada más para que recoja sus cosas, sus objetos personales, sus pertenencias.
While this order is in effect, you're also prohibited from carrying a gun, a weapon, or ammunition.
Mientras esta orden siga vigente, a usted se le prohíbe estar en tenencia o portar armas, armas de fuego o municiones.
Thank you.
Gracias. Puede retirar.
And then, Your Honor, just for the record, were the public defenders appointed on all 6 of the cases?
That's correct.
Thank you, Your Honor.
So for the record, if there is some issue as to immigration, it's the burden of the state to present that to the court. All right?
Thank you.
Corrections.
Hoping that we don't have any notifications on that.
Yeah, but house arrest is 3 different levels. Level 1 is total lockdown, they can't do anything but go to court and hospital. Anything else they can do anything without the court approval. Level 2, they're about to go to work, school, medical appointments, grocery, cancer, religious service, attorneys, but they have to get approval from their officer. They have to show a lot of proof that they have to go there. Level 3 is restricted, they can do whatever.
But we're monitored.
Correct. All of them was with them monitor, no matter what. I'm not here from this meeting, but.
Are we doing it right now?
That's your question.
Thank you. Morning, how are you?
Where to stamp? You know how to stamp? Better be fine.
You can tell me.
Okay.
Young man, first with the COA owners and charge for the seniors.
Okay.
Your Honor, this is Joanna Hennessy. I'm here for the jail arraignment calendar. I'm assuming we're starting that right now. I'm here with the city of Miami Beach.
Yeah, we haven't started yet.
I'm just letting you know I'm here. Thank you, Your Honor.
Okay, I'm gonna, I already wrote the bond out, and this is the home time, the date we're gonna use, okay, Judge? So before we get started, we'll find the bond out. Right, here, bond out, please, right here.
And sign here.
Yeah.
Bond out.
Yeah. You got yours too? Yeah. You go on down on that one? Okay, you know.
I didn't say.
Here to go. Unless you're counting the followers.
Right, Tanya Oliveira. Olivier, I'm sorry.
Judge, she has a fugitive from Palm Beach County being held no bond on that.
So Your Honor, can she be ROR'd on the charge in Miami-Dade County so she can be transported to Palm Beach and then address her case there? She has 2 children she needs to get to before the end of the weekend. It's a resisting an officer without violence charge here.
Let me look at the arrest affidavit and determine if there's probable.
Thank you, Your Honor.
Who's that? I don't know who's talking.
This is-
Right, the court finds there's probable cause for the misdemeanor resisting.
Judge, we'd be asking for standard bond amount of 500 for each count.
Why are there two counts?
Because I think it's two different incidents or at the same time, Your Honor. Two separate incidents. It could also be she resisted multiple officers as well, Your Honor. We can charge it like that as well.
And Your Honor, notwithstanding the probable cause that you found, you can still release her on her own recognizance. We're not requesting that she be released outright for lack of probable cause.
The court did find probable cause. I'm not going to release her on her own recognizance when she had an open warrant and it appears that she was attempting to evade arrest.
Right.
So I do find that there's probable cause, but I'm not seeing why there's two counts. I'll set the bond at $500.
For one count, and then what about the other count, Your Honor?
Zero.
Zero.
Judge, I'm sorry.
50 and 250. Would you like that?
That's fine, Your Honor.
Okay. Where do I write on here, Madam Clerk? Thank you. It'll be 250 on count one and 250 on count two. Tiffany Taylor?
Actually, let me get this one was the bond now. Can I get the?
Ms. Taylor, you're charged with
Just
trespass,
for the bond now?
disorderly intoxication, resisting without violence. Let me review the arrest affidavit.
Yeah, was
Actually, Cameron, can you do me a favor? Can you go through his calendar and like put BO or off calendar? Bring on. Just copy your calendar.
Yeah, the court does find that there's probable cause for the trespass, disorderly and resisting. What is the state's position on bond?
We'd be asking for standard bond on each count, Your Honor. So for the trespass, it'd be 500. For the disorderly, it'd be 150, and for the resisting, it'd be 500.
Defense?
This is the first one.
The Lieutenant, I can't hear you. Are you saying anything?
I'm so sorry, Your Honor, I was on mute. The defense would be requesting that she's released on her own recognizance. Her last conviction was from 2019, and all of the violent ones were from more than 10 years ago.
Does she qualify for pretrial services?
No, Your Honor, and we'd be objecting to pretrial services or an RR, given her priors, if I may read.
Go ahead.
She has a 2014 battery, an aggravated battery with a harmful weapon, conviction from 2014, leaving the scene with seriously bodily injury from 2014 conviction. And she also has previous resistings and disorderlies from 2019 and a previous trespass from 2015. So my argument is she keeps picking up these same cases. It's the same charges that she's been convicted of before.
All right. What is the bond that you were requesting on count 1
500 for the trespass, Your Honor.
and 2
150,
and 3?
500.
All right, so it'll be 500, 150, and 500 for a total of 1150.
And Judge, I do believe there's a stay away order that should be in the stack.
From
Yeah.
Winn-Dixie.
Yes.
Okay, I'm also going to enter an order, Ms. Taylor, that you're to stay away from the Winn-Dixie at 1150 Northwest 54th Street.
That's not true. Okay.
Jessica Rolfo. There are 2 8 forms. Are they different?
Yes, Judge.
Okay, there's 2. I see. All right, there's 2 arrest affidavits for petty theft. Let me just look at them. Oh, sorry, this is M 254594. Court finds probable cause on that one. What's the state's position on bond?
Judge, we'd be asking for standard bond in the amount of 150 on both cases. Reason being is this is she has 2 open petty thefts as of right now. She recently closed out a petty theft from 2025 to a withhold on the 5th, which I believe was 3 days ago. And she picked up these other 2 cases very recently. I believe one of them was on March 2nd. So for these reasons, we'd be asking for bond 150 on each.
Your Honor, we'd be requesting a release on her own recognizance. She has no prior convictions. It's a withhold of adjudication, and she's before you today on 2 counts of petty theft, allegedly for stealing food from Publix. She has not bench warranted in the past.
Your Honor, we'd be objecting to pretrial services, given her recent violations of the law, and they're constant at this point.
Constantly no prost, Your Honor, not convicted. There's no reason to believe she wouldn't show up to her court date for the allegations of stealing food from the supermarket.
Does she have a local address? How come corrections isn't here for you?
She does have a local address, Your Honor.
No.
The allegations she was stealing food.
I understand, Your Honor. However, it's still a crime. I'm not going to say she's going to be given a long sentence, if any, but it is a crime.
Okay, for case number 254594, I'm going to find probable cause. Release her to pretrial services, alternate bond $150. And for case number 254595, I also find probable cause. Same. I'll release her to pretrial services with an alternate bond of $150. I'm also gonna enter a stay away order. Assume that there's one prepared here. For the Publix at 911 Southwest First Avenue. Ma'am, you're to have no contact with that Publix. You understand? Okay. Can you ask her if she can give us a phone number?
Yes, Your Honor, one moment, they're bringing her back.
728-227-0815.
Was the state and Your Honor able to get that?
I was not. I was writing something.
I can repeat it, Your Honor. It's 728-227-0815.
0815. Talia Elizabeth Johnson. Morning, Ms. Johnson. You're charged with petty theft. Let me look at the arrest affidavit. Court finds probable cause. What's the state's position on custody release?
Judge, the state is okay with an ROR if she has an address, and if she doesn't have an address and is homeless, we could ROR her and place her on the homeless calendar.
Counsel, does she have a local address?
She does, and thank you for the ROR, State. I can read the address onto the record now.
Go ahead.
1510 Northwest 114th Street, Miami, Florida 33167.
Ma'am, you're going to be released on your own recognizance. Make sure you appear for court after you get the notice. There's also going to be a stay away order from Nordstrom's 4310 Ponce de Leon Boulevard. You cannot shop at Nordstrom for the next 6 months. Shop somewhere else. Marie Roseme.
Judge reset for tomorrow, she refused.
March 9th, right?
That's an extra date.
Defendant refused. Armina Fay. Ms. Fay, you're charged with petty theft. Let me look at the arrest affidavit. Court finds probable cause. What is the state's position on release conditions?
Judge, the state will simply to an ROR if she has an address, or ROR place her on the homeless calendar if she doesn't.
Counsel, does she have an address?
She does have an address. I can read it.
Please do.
19501 West Country Club Drive, Unit 2106, City Aventura, Florida, zip code 33180.
Okay, I'm going to release you on your own recognizance, Ms. Fay, but I'm also going to order you to stay away from Macy's and Dayland. You'll have to shop somewhere else for the time being. Okay? Yeah. All right. Josephine Lee. Good morning, Ms. Lee. You're charged with petty theft. Court finds that there's probable cause. What's the state's position on custody release conditions?
Judge, the state would be asking for a bond in the amount of $500 for this case. The defendant has 3 petty theft convictions within this year and last year, 2024, along with a 2024 withhold for petty theft as well. And she does have another open petty theft case at the moment, other than this one. So for that reason, we'd be asking for an elevated bond of $500 because she keeps reoffending and it's the same charge again.
So she picked up this case while another one was pending?
Yes, Your Honor.
Defense, is there anything you want to say?
It just requests the standard bond on this case of $150. It's a petty theft.
I'm going to set the bond at $250. And I'm going to enter a stay away order from the Family Dollar Tree. Ms. Lee, stay away from the Dollar Tree at 904 West Palm Drive, Florida City, Florida. For the traffic bill.
Yes.
Amanda Marie Baker.
Your Honor, Ms. Baker has refused this morning.
Okay, this looks like it was reset from yesterday. Is that right?
Yes, Judge, and now she refused today again.
So reset it to tomorrow. Clerk, do I just write that on this page here? Reset.
Same area.
Okay. Looks like Jamisha and Tanika Walker. DWLS. Okay.
1 second, Your Honor. Can we ask if she has a local address?
She does have a local address.
And does she have a reference as well?
What was that?
Does she have a reference for pretrial services? That's what I'm asking.
Madam Clerk.
She does.
Okay. Judge, in this event,
She got picked up on a picture. It was a report on this date.
So this is here in Dade County, or?
Yes, this is here with Judge Nelson. She issued a big one that amount and a report that she did not report to on that date. That's all that's indicated to her. Of why she got picked.
right, so Judge, she failed to appear. That's why this case is before Your Honor, because this bench warrant was issued because she failed to appear. The state will request pretrial services with an alternate bond of $3,501 to match the bench warrant amount. She does say she has a reference and a local address. So.
Okay, so it'll be pretrial services with the alternate bond of $3,501. Anything else on that?
No, Your Honor, thank you.
Jonathan Alfonso Daniels. Mr. Daniels, you're charged with indecent exposure. The court will review for a probable cause.
Does he refuse?
Who's that?
Mr. Daniels.
Yeah.
There was a note from yesterday.
He refused, Judge.
Not
This-
brought to court, additional charges, special unit. Okay,
He said Mr. Daniels refused.
yes.
Yes, he refused.
I'm gonna reset it then to 3-9. Julio Rodriguez. Is this Mr. Rodriguez before us?
Yes, Your Honor.
Mr. Rodriguez, you're charged with petty theft. The court will review the arrest affidavit. State, what's the threshold for grand theft?
Grand theft is over $750, Your Honor.
All right, the court finds probable cause. What's your position with custody with respect to Mr. Rodriguez?
Can I actually ask corrections? I think corrections, I see that he has two.
Added charges. This is added.
He sees no bond.
Correct. This is added charges.
Okay, these are added charges. Okay. Judge, in this case, then the state is fine with standard bond of 150.
All right, this court will set a bond of 150 in this case, Mr. Rodriguez. Into the bench. Brandon James Wells. Good morning, Mr. Wells.
Added charges, Judge.
These are added
This
charges.
is, yes, these are two added bench warrants. He's been in custody since February the 11th.
So he's being arraigned on the resisting.
What's before you is the two cases of resisting officer with violence or without violence.
Okay, the first one I have is B 2421408. If the court finds there's probable cause, what's the state's position on custody?
Standard bond of 500 for each is fine, Your Honor.
Well, this is one count of resisting.
But he has two cases, Your Honor. So,
I'm on the first case, right?
oh, okay. So 500 for the first case.
Defense, is there anything you want to say?
Your Honor, we'd be requesting PTS for Mr. Wells. He doesn't have any prior convictions. I understand the other open cases, but the PTS can confirm that he'll show up to his court dates for them, and we can provide an address.
He has other open cases, State?
Yes, Your Honor.
What is that?
He also has an open felony battery on a law enforcement officer and resisting an officer with violence. He's likely gonna be back for the felonies when we get to that, so we're likely to set a bond there.
Okay, so I'm gonna set on
He
this,
will not be back on the bond hearing calendar. Only the misdemeanor bench warrants are being addressed. Those other cases that he's in custody on, he's been addressed on already.
What was the bond for those corrections?
One is,
The F-25 2946, he had a bond of $5,000. And then he went back to court and then the state filed charges for a battery on a Leo. And he received house arrest alternate $5,000. And this,
for this case, I'm finding PC $500.
said
Well,
on
Case number 24-21408. I'm now on case number 24-19001. In this case, Mr. Wells, you're charged with resisting of an officer without violence. Driver's license, non-resident requirement violation, and motor vehicle, no registration. I'm gonna find probable cause. What's the state's position on the bond?
Judge, we've been requesting again standard 500 for the resisting and then 150 for each of the traffic matters.
the traffics are off calendar. You're
Traffic-
on-
Oh, sorry.
Okay, so it's just the resisting.
Is he resisting? 500, Your Honor.
$500 bond.
Yep.
Charles Alexander Barios.
Your Honor, for James Wells, is that $500 on both counts of resisting?
I thought it was only one count of resisting.
You have two cases, both cases, each count, one count on each case is 500.
Correct, correct. Charles Alexander Barrios. Mr. Barrios here? Good morning, sir. You're charged with disorderly conduct and trespass. The court will review the arrest affidavit. The court finds probable cause. What's the state's position on the conditions of release?
Judge, we'd be asking for elevated bond in the amount of $1,000 for the disorderly and $2,000 for the trespass. The defendant has 1, 2, 3, 4, 5, 6, 7, 8 convictions for armed robbery or armed burglary, that were convictions from 2019. That's an offense punishable by life. He got a conviction on 8 of those. And furthermore, Your Honor, because of that, we'd be asking for an elevated bond in this case.
Defense.
Your Honor, we're asking that he be released on pretrial services. There's no reason to elevate the bond. The bond is to assure that he'll show up to court, and clearly he's showing up to court if he has all of these convictions. Elevating his bond is merely punishing him for a past criminal record. He's not a flight risk.
No, but I can take into consideration his criminal history when setting the bond.
Understood, Your Honor, but we would graciously request that this young man be released to pretrial services.
I'm going to graciously deny your request and set the bond at $1,000.
Notice, Your Honor.
So what's the standard bond for disorderly
150, Your Honor.
and for trespass?
500.
Okay, so there'll be 100 on disorderly and $900 on trespass.
Judge, you said $900?
Yeah, so a total is 1,000. Count 100. Count 2, 900. Harry Maurice McRae Jr.
He'll be reset for tomorrow, Judge. He was moved to a pretrial detention center.
Miguel Angel Varigarra. Good morning, sir. You're charged with petty theft. Court will review the arrest affidavit.
One moment, Your Honor, they're bringing him in.
Okay. Mr. Miguel Vergara, does he speak English? Do we need the interpreter?
He does speak English, Your Honor.
Mr. Vergara, you're charged with petty theft. The court does find that there's probable cause. What is the state's position on release?
Judge would be asking for an elevated bond of $1,000 in this case. He has while they're dated, he does have a lot of grand theft convictions from 1995. I haven't counted them all up, but it's over 10. And furthermore, he has a burglary with an assault or battery punishable by life conviction from 1995 as well. So for those reasons, we'd be asking for an elevated bond in this case.
When was the last time that he had contact with the system?
With the system, Your Honor? Well, he had a 2024 arrest for petty theft. The case was no process, however, if you count that as contact with the system in 2024, he was arrested. Furthermore, I do see that he was at one point a fugitive for an out of state that was quashed in 2023. His last conviction or withhold was in 2017, which was a trespass after warning.
Defense. Anything you want to say?
Your Honor, I'd be asking for the standard bond in this case. As Your Honor noticed, the convictions are from over 25 years ago. His last run-in with the system was an arrest that was dismissed. So standard bond for the petty theft is what we'd be requesting.
What?
150, Your Honor.
Okay, I'm gonna make it 250. And is there a stay away order here?
Yes, Your Honor, there should be. Say where.
Mr. Vergara, you're ordered to stay away from the Publix at 4870 Biscayne Boulevard.
And Judge, do you also have another case as well? Yeah.
What case number, please?
I'm sorry. It is 250 on case number M254522.
Yes, nothing. Okay.
Check this. Yes, I have another case. Oh,
Right.
it's an arrest warrant?
Yes, Your Honor. A $10,000 arrest warrant.
Petty theft?
Right, Your Honor.
This is from 2024. But he's never appeared on this case before. This was a promise to appear.
Right, Your Honor, it appears so.
I see a thumbprint. So I assume he did promise to appear, failed to show, and it was a $10,000 agreement.
Yes, Your Honor.
That's the state's position in this case.
Judge, we'd be asking for elevated bond in the amount of 1,000 for this one.
Defendant? What's your position?
Your Honor, we'd be just requesting the standard bond. This is a petty theft allegation from Publix again.
I know, but the problem is, the purpose of the bond is to ensure that he appears for court, and he didn't appear for court on this case originally, so. Does he have a local address?
He does have a local address, Your Honor. Would you consider PTS?
I won't consider pre-trial services. Just wanted to make sure that he lives locally
Yeah, I had you.
at $500.
Judges at each case, pretrial alternate 500.
This case, there's one count of petty theft and setting the bond at $500, case number 24-27926.
Total 750.
Correct. Alani Mesa? Mr. Mesa, you're charged with trespass after warning. Find probable cause. What's the state's position on bond?
Judge, the state would be asking for an elevated bond in the amount of $1,000. Reason being, I understand it's a trespass, however, he has a lot of priors, a lot of them very recently from 2024 and 2023. And it's just a recurring issue, so therefore we'd be asking for an elevated bond.
What are the priors?
A lot of trespasses, Your Honor, I could count them up, but it's definitely over 10 in the last couple of years. Does have a lot of petty theft as well, petty theft, trauma conviction, felonies, grand theft. So
What's the standard bond?
the standard would be $500.
What's your position?
Your Honor, wait, can he be granted TAP in this case?
I don't get it.
Corrections, would he qualify?
A TAP representative is not here on the weekend.
In that case, Your Honor, we'd be requesting the standard bond for the trespass.
Based on his history, we'll set the bond at $500. And there's gonna be a stay away order for apartment building located at 1446 Ocean Drive, Miami Beach, Florida. Here's Tony Guignard.
They're bringing him in, Your Honor, one moment.
Good morning, sir. You're charged with trespass at 826 Collins Avenue. Find probable cause. State, what's your position?
Just one question. Corrections, was he out on felony bond, for case F 24 26451 before this?
I don't have it on my jail card. What's the case number?
It's F 24 26451.
You say he has an open case or?
Yes, Your Honor, he has a couple open cases. I'm just asking if he was on bond before he picked this case up.
What is the open felony?
It's a cocaine possession, drug paraphernalia with an intent to use, and a camping prohibited.
Yes, he's out on bond. I show his next court date is 3/24.
Judge, we'd be asking to place a hold on the felony and then ask for standard bond in this case of 500.
Set the bond at $500 in this case.
And Your Honor, are you granting the hold? The defense would be objecting to the hold. It's a trespass.
Judge, that state's position that he picked up a case after he was already out on felony bond. Therefore, we'd ask that you grant the hold and let the felony judge deal with the bond, however they want to address it.
Do I have authority to do that if that case isn't in front of me today?
Yes, Your Honor. You're the first appearance judge for the other case. You could hold them. You're not changing the felony bond. You're just putting a hold on it so he can't get out.
Correct, Your Honor, and that is because he picked up an allegation of trespass.
I understand. All right, you have to place the felony hold on the other case.
And the bond on the new case is 250, you said? I'm sorry, Judge, we can't hear you.
$500.
Yeah.
Is there a stay away order too here?
Yes, Your Honor, it should have been one of the panel.
Okay. Can you bring him back, please? I'm sorry, corrections. Yves Guinard to stay away. Mr. Guinard, you're also ordered to stay away from the property at 826 Collins Avenue, Miami Beach. Since you have an open felony, there's going to be a hold on that case until you can appear in front of the division judge. Kevin Tay Campos. Is Mr. Campos here? Okay, Mr. Campos, you're here on a warrant. Is there already a written plea or in here? What's this posture of this case? This is case number B24559.
And that has 2 counts on that case.
Petty theft?
Right, it looks like the defendant was ROR'd, possibly at first appearance or at some point, and then he did not appear for his next court date, so the bench warrant was issued, Your Honor.
It's already an information file.
Right, Your Honor, because it's an open case at the moment. He picked up a bench warrant by not appearing for a status date, for report date.
What would the state have me do?
Well, Your Honor, the state for the bench warrant case would ask you to convert the bench warrant amount into the bond, which would be $650. Yeah, which would be $650.
Set the bond on count 1 at 150 and count 2, $500.
Your Honor, would you consider granting pretrial services for Mr. Campos?
Not when he already failed to appear for court.
Noted.
He has a second case.
Right, that's another petty theft, Your Honor.
Case number 23-15684. Is this the same posture?
It looks like it, Your Honor.
Petty theft? He
The
failed to
bench
appear?
Yeah.
Right, what's the state's position?
We're asking for you to convert the bench warrant amount, so again, 150 for this one.
$150 bond. You'll appear in front of the division judge, Mr. Campos, if you cannot fund. There's also a stay away order. Mr. Campos, you're ordered to stay away from the Home Depot at 12005 Biscayne Boulevard. Daniel Ambrose. Mr. Ambrose, you're charged with petty theft. We're going to review the arrest affidavit. Court finds probable cause for the petty theft charge. What's the state's position on bond?
Judge would be asking for an elevated bond in the amount of $2,000. Reason being, he has 3 petty theft convictions, 2 of them being from 2024, late 2024, 1 being from 2023, along with 2 felony petty theft withholds from 2024. He keeps picking up the same charge again. So for this reason, we're asking for elevated bond.
Defense?
Your Honor, we'd be asking for the standard bond in this case. The defendant is homeless, and the allegation is they were stealing Ensure from Walgreens. I understand the other petty theft convictions, but it's always food. In this case, it's a protein shake.
Set the bond at $500. Is there a stay away order? Yes. Mr. Ambrose, you're ordered to stay away from Walgreens at 151 Northeast 54th Street. Alan Babasa Salas. This is a bench warrant on what?
On a petty theft, I believe, Your Honor.
Okay, what's your position? 2 pairs of sunglasses from Walmart.
Right. Does he have a local address?
Total value $34.94.
Yeah. Does he have a local address and a reference for pretrial services?
He does. I can read it for you.
Okay.
And just to confirm, this is Mr. Ravasales?
I have, well, the way it's spelled is Babasa Salas.
Got it. Address 12974 Southwest 20th Terrace, Miami, Florida 33175.
Are you agreeing to pretrial services?
Yes, Your Honor. Pretrial services with the alternate in the amount of $1,000, which was the benchmark amount.
Services with an alternate bond of $1,000. There's a stay away order. Mr. Rabasalas, you're to stay away from the Walmart at 861, 80. Circular out. Count two as well.
Correct.
It's two separate cases, a misdemeanor and a traffic, so. The misdemeanor is the pretrial alternate 500, the B 25-4611, and the traffic case is pretrial alternate, I have 150 on the jail card.
Okay, it's 150 then on the reckless driving.
State, you need the address from him. I've confirmed it's the one on the A form.
I think you, for the clerks, you should read out for the
Okay,
record.
noted. 9547 Northwest 4th Avenue, Miami, Florida, 33150.
Meaning, you call him now? Okay.
There's an add-on. Can I get the case number?
Brandon Chase. I will read it out.
Your Honor.
M241734. He twice refused court.
Yes, but he's here now. On his felony case, he refused as well, but they waived the presence and they gave him a bond of $1,500.
Correction. What's the charge on the felony, if you don't mind?
Cocaine possession. Drug paraphernalia, possession with intent.
Oh, this is a panhandling.
While on routine patrol, I observed Brandon Chase with a cardboard sign in hand which said money for police.
Yeah.
I can't see what that says, but
Judge.
he was begging for money.
Right. An aggressive panhandling charge. There's actually, the state will make an announcement on this case.
All right.
In case M241734, state announces an all prosecutor discretion. So it's a felony, but.
Mr. Chase, they dismissed the panhandling charge. There's another case with Mr. Chase, which is the bench warrant M241732. Bench warrant for aggressive panhandling.
Judge, that's case M241732, state announces an all prosecutor discretion.
That case is also dismissed. But he has a felony case later
Correct, Your Honor.
today.
No,
That's already been addressed. He received a bond of $1,500 because he refused, so they waived his presence.
Very good. Thank you, corrections. I have David Ariel out, P-A-U-T. Mr. Pop, you're charged with leaving the scene of an accident causing property damage. All right, the court finds probable cause, state.
Judge, the defendant has no priors or traffic priors, no crime or traffic priors. However, given that this was a hit and run essentially, we would be asking for bond in the amount of $500.
Defense.
Right, the defense is asking in light of the no priors that he be released on his own recognizance. If your honor is not inclined for that, at least pretrial services, he does have an address that's valid.
Can you have him confirm his address?
Yes, the address is 11608 Northwest 4th Terrace, Sweetwater, Florida, 33172.
What's the standard bond?
I believe it's 500, but I could be wrong. It might be 150. However, let me
I
just-
believe it's 150.
Leaving the scene with property damage.
It's 150.
Okay, I'm gonna do pretrial services with the alternate bond of 150. Vigorel, Guyan, Enriquillo.
Judge, he has a new felony case. He'll be back on your bond hearing calendar later.
To be continued.
Oh, we still have to address this misdemeanor, Your Honor.
I'm sorry?
We still have to address the misdemeanor.
Oh,
Yeah.
you know. Okay, does he speak English, counsel? Okay, Mr. Enriquillo, you're charged with DWLS while suspended, canceled, revoked. State. There's a bench warrant issued on February 12th by Judge Cuervo for $1,000.
Great. Judge,
He has an open felony.
correct. He has an open felony, criminal mischief over $1,000, and a battery included with that. Given that he's likely to get bond, in that case, we'd be asking for just the standard bond in this case of 150 for the DWS.
Defense, any objection?
No, your honor, standard bond's okay.
Okay, $150. Miguel Merrill. Case number, well, this is a traffic violation probation, is that right?
It looks like it, Your Honor. It looks like a close.
A DUI.
Yes.
State.
Judge, given it's a DUI, this is probably one of the more serious traffic offenses. We'd be asking for you to convert the bench warrant amount, considering that he failed to appear after he closed the case for report status, probably. So for that reason, we'd be asking for you to convert the bench warrant amount.
Defense, what's your position?
No, your honors, if the case is closed out, we're requesting that he be, that the bond be set at $1,000. If the DUI was closed and it was a status that he failed to report for.
It says he failed to appear for intake, which would be like the first step in the process, wouldn't it?
Right, and that,
Right?
right, and this happened back in, I believe, 2000, in the late 2000s, Your Honor. This is an older case, but it's been over a decade since this case was closed out and he decided to not appear.
All right, I'm gonna set the bond at the bench warrant amount of $5,000. Willie C. Lee.
He has a new felony. He'll be back on the bond hearing calendar. You're addressing the traffic case now.
He has a misdemeanor too, though. Oh, I see what you mean.
Yeah. They're related felonies, Your Honor, but
I got it.
Yeah.
So, Mr. Lee, this morning you're just here for the driving with license suspended knowingly? State?
well, 1 second. Your Honor. Judge, we'd be asking for a bond in the amount of $500 for the DWS, and the reason why for an elevated bond for DWS is because he has 6 previous DWS convictions. I understand some of them are older, one from 2009, one from 2001, one from 2000, two from 1990, and one from 1983. However, it's a driving with his license suspended. He has noticed that he's gotten caught before, 6 times actually, and he continued to.
So you said $500?
Right, Your Honor.
The court's gonna set bond at $500 only on the DWLS. We'll be back to see him later on the felony calendar.
The standard is 150.
Right. Another.
Right, because he has a history of traffic violations.
7.
How many more?
7 more for my count, Your Honor.
Then I have to take a break after that.
Yeah, that's understandable.
We need a break?
Probably.
All right. Dominguez, Rodriguez, Enrique. Or do I have that back?
I think it's Enriquez, Rodriguez, Dominguez. Last name Dominguez.
Your Honor, he will need the services of the Spanish interpreter.
Okay. I'm sorry, what is the correct last name?
¿Cuál es el apellido correcto?
Dominguez.
Okay, he's charged with DWLS. I'm not sure I understand what the reason is, but state
Judge, he has.
bench warrant was set at $10,000.
Yeah, that's probably a Judge Correa bench warrant, probably because he failed to appear at trial.
I'm sorry, did you say something? What was that about trial? You said?
I think the judge was asking for clarity on why it was a $10,000 bench warrant. I was explaining to him that it was probably my judge, Judge Correa, who normally sets $10,000 bonds when they fail to appear at trial.
I got it, thank you. Señor, enfrente del cargo de manejar con la licencia suspendida, tiene una orden de arresto de $10,000. El juez se preguntaba por qué. El fiscal dice lo que pasa es que hay una juez, la juez Correa, cuando la gente no comparece para el día de juicio, la juez fija una fianza de $10,000.
Okay. And Judge, looking at the defendant's driving record, he has a previous DUI conviction and a couple.
Sorry,
That's okay.
what's the suspension he was driving?
Let's see.
Was it 40 years?
No,
Entonces, este acusado tiene un fallo inculpatorio, condenatorio del pasado por manejar bajo los efectos.
He has a DUI conviction?
He has a DUI conviction. It is older, Your Honor, so the revocation had already expired. However, the reason why the license was suspended in the first place is because he failed to appear for traffic summons. So he picked up tickets and he never appeared for court or paid.
Y la razón por la que la licencia está suspendida es porque tenía comparendos o partes para tránsito y nunca vino a responder ante ellos.
Right. And for that reason, we'd be asking for not you to convert the bench warrant amount. I think that'd be a little much. However, we'd be asking for the amount of $1,000 for the bond.
Entonces ahora estamos pidiendo en este caso bajo fianza la cantidad de $1,000 por fianza.
Defense?
$1,000 is all right, Your Honor. Thank you for acknowledging that 10,000 was not appropriate at all.
Entonces el abogado defensor está de acuerdo con la fianza de $1,000.
$1,000 bond.
Entonces fianza de $1,000.
$1,000 bond, Judge?
1000.
This is some cuts out sometimes.
I'm sorry. Ernesto Cardinus. Two cases, it looks like.
Your Honor, if I may, this is Joanne Hennessy for the city of Miami Beach. I think you're done with the misdemeanor portion of the jail arraignment calendar. If I could just be excused.
You may certainly be excused.
Thank you.
You too. Ernesto Cardinus. Mr. Cardinus, does he speak English?
He does speak English, Your Honor.
Okay, there's two cases here. I have one with a bench warrant for driving while license suspended or revoked. Case number was A7VL6NE. Bench warrant $1,000. And then case number 5592 WNC, also DWLS. Bench warrant $1,000. State.
Judge, we'd be asking for 500 on each for a total of 1,000, given he has not one but two bench warrants, and he also has 3 previous DWS convictions in the past.
Any objections, defense?
No, Your Honor.
That'll be $500 on each case. Garello Jakome Roas.
Your Honor, we'll need this services of the Spanish interpreter.
Present.
Good morning. He has 1, 2. It looks like 3 cases, clerk. Is that right?
Tiene 3 casos pendientes, parece.
Yes, sir.
Okay. Mr. Jakome Roas, you have 3 cases with bench warrants where you failed to appear for court. The first is AJK 4QQE.
Señor, tiene 3 casos con órdenes de arresto pendientes por no haber venido a comparecer ante la corte. El primero es un caso que termina en QE.
Okay, that is driving with license suspended.
Es por manejar con la licencia suspendida.
And then case number ADH2HVE, which is GWLS, driving with license suspended.
Después otro que termina en HBE, que es por manejar con la licencia suspendida.
And then AL2DYJE. No
Y otro
license.
otro que, es, que termina en JE por manejar, por no tener licencia válida para manejar.
State.
Judge, the state will ask for 500 on both DWS, so for a total of 1,000 and 150 for the no valid driver's license.
Señoría, estamos pidiendo para ambos cargos de manejar con la licencia suspendida, $500 de fianza para cada uno, para un total de 1,000 y 150 para el de no tener licencia.
Anything the defense wants to say?
No, Your Honor.
¿Qué
Okay,
tiene que decir la defensa? Nada.
so the court finds probable cause for the new case of no valid driver's license in state. You said the bond on that was
On the no valid driver's license, 150, Your Honor.
$150.
Entonces hay motivo fundado para el cargo de no tener licencia válida para conducir y la fianza son $150.
And for the other 2 cases, it's $500 each, correct, state?
Correct, Your Honor.
Y 500 para cada uno de los otros.
Your Honor, may I use the Spanish interpreter briefly?
Certainly.
Madam Interpreter, Mr. Interpreter, can you just explain that he can pay the bond and be released?
Señor, usted puede pagar la fianza y puede ser excarcelado. Si paga la fianza, lo pueden soltar.
¿Cuánto es?
So how much is that?
His bond is totaled at $650. A bondsman may allow him to pay 10%, which would be $65 in the event the bondsman.
It's actually 5, and 150.
El total son, so once again, counsel for the interpreter, please. So the total is how much?
It's 1150, so whatever a bondsman would charge for a bond of 1150.
Entonces sería un total de 1,150. Un fiancista le puede cobrar solamente el 10%, lo que quiera que sea la cantidad que corresponda a el 10% de 1,150.
Alain Agier Galves.
They're bringing him in. One moment, Your Honor. Your Honor, he will need the Spanish interpreter as well.
Present.
Mr. Gary Galvez, you're here for a bench warrant on a this
I believe it's a DWS, Your Honor.
is it?
Or no valid driver's license, actually.
Está aquí por una orden de arresto por no tener licencia válida para manejar.
So I only see, I'm just looking at a citation here that says no valid driver's license. Okay. You didn't show for court on the 19th of February in front of the judge? State?
Señor, usted no vino a comparecer el 19 de febrero frente al juez que tenía que venir.
Judge, he has no priors or traffic priors either. For that reason, we're okay with the standard bond of 150.
Dice la fiscalía, él no tiene antecedentes penales, así que no hay problema, dice la fiscalía, con que le dejemos la fianza estándar de 150.
Defense?
No, no objection, Your Honor.
No hay objeción de parte de la defensa.
Okay. The bond will be set for $150, sir.
De $150 de fianza, señor.
If you post bond, then you'll have to report to court.
Entonces, si paga la fianza, puede pagar la fianza, pero tiene que volver a reportarse ante el juez.
Lazero Compost.
He has a new felony case. He'll be back on the bond hearing calendar.
Okay, Mr. Compost, you're here this morning for the traffic DWLS, driving with license suspended. Court finds probable cause. State, what's your position on the DWLS only?
Judge, as for the DWS, we're asking actually for an elevated bond in the amount of $1,000. Reason being, he has multiple previous DWSs. I count 1, 2, 3, 4, 5 previous DWSs, along with 2 fleeing and eluding convictions from 2021 and from, what was the other one? He has, actually, I think he may only have one. Yeah, he only has one fleeing and eluding, but from 2021 conviction. Given his track record for having a pretty bad driving record, Your Honor, we're asking for an elevated bond.
Defense?
Your Honor, we're asking for the standard bond of 150. He'll be back this afternoon for a bond on his felony as well, but he hasn't displayed it that he wouldn't come to court. So standard bond on the traffic case should be sufficient.
There's just, what are the suspensions for, State?
Let's see, Your Honor. The suspensions are his most recent one is for a violation of chapter 893 of controlled substance. Not entirely 100% certain on exactly specifics of that, but it has something to do with probably having some drugs on him and previous conviction. And he also has some traffic tickets that he has failed to pay, and therefore his license was suspended
I'm
as a
gonna
result.
set bond at $500. And he'll be back this afternoon for felonies. Is that right?
Right, Your Honor.
Eric Miguel de Casada Silva.
He has a new felony. He'll be back on the bond hearing calendar.
Your Honor, we will need the Spanish interpreter for this.
All right. Did corrections you say he'll be back later for a felony?
Yes, Your Honor.
Yes, Judge.
Okay, Mr. de Casada Silva, you're here on your traffic offenses only. This is first one, AL5JMME.
Señora,
Resist-
aquí solamente,
Yes, Your Honor.
I'm sorry, Your Honor, the interpreter interrupted. I apologize. What were you saying, Your Honor, please?
The first case is a no motor vehicle registration. State.
Señor, está aquí por varios casos que tienen que ver con tráfico o tránsito. El primero es porque no tenía la registración del vehículo.
Just given the type of offense and given that he has a related felony, we're just gonna ask for a standard of 150.
Estamos pidiendo por ahora la fianza solamente de de $150, dado que tiene el caso de delito grave.
I'm gonna set the bond at 150 on this case.
Para este caso tendrá fianza de 150.
The next case is unlawful use of a temporary tag.
El otro caso es el uso ilícito de una placa o chapa.
This is case AL5JMPE. State.
Same thing, Your Honor, 150.
The board has set the bond at $150 on this case.
Para ese también la fianza van a ser $150.
I have 500 on the jail card.
Well, the state is saying 150,
Well,
so
We'll reduce it to 150 given the felony correction.
Es 150, dado que también tiene un caso de delito mayor o de delito grave.
No objections, Your Honor.
No objeción.
then I have Harvey Diaz. Was the last one.
Yes, Your Honor.
Mr. Diaz, I have two cases. First is case number AKVCFBE. You're charged with DUI causing damage or personal injury. State.
Just given the nature of the charge, we'd be asking for $1,000 bond on this case.
Okay. Defense.
Your Honor, he has a valid address. He can confirm we'd be requesting pretrial services.
Any prior state?
No prior DUIs, Your Honor, or prior crimes. However, I will know that he has a conviction for having an open container of alcohol back in 2016. I don't want to suggest anything, however, given the nature of the charge in this case, having an open container in the past and then driving under the influence in 2025 is probably an indicator. So that's why I'm asking for $1,000 bond.
Well, let me just look at what the other ticket is for.
The other one is for regular DUI.
Is for what?
Regular DUI. The first one is with property damage or injury to person. The second one is the regular driving under the influence.
All right. Well, this one has an eighth one. Let me read. Wait, what's your position on the DUI case?
Same thing, Your Honor, 1,000 for that count as well. That's a standard.
1,000 for both cases?
Correct.
Or finds probable cause and set bond at $1,000 for each case. Of all of these that are not signed.
Judge, and we have the felonies if you're ready.
All right, I'm going to take a brief recess. Thank you. Water bottle upstairs on the ground. Also, removing the power net.
If I started bonds at 9.
Too early. Anyways, what's your okay, ma'am. Probably read faster than I do, so yeah. It doesn't help me. I'm sure you can see.
But you got here, I need to week from. Also, it's great. Please go ahead.
If are they? What's your? Yes, they are with you. There you go. Yep. Yeah. No, we haven't even started calling these. But thankfully, there's no truth there. How many photos you have? 16 pages worth. 17, I'm sorry. The optimism, right?
Well, technically 18, but
I had the same price.
yeah, two right. We got counts. 40, yeah, we have counts. Another guy 5 feet, original art in town.
Huh? My experience with one case, one staff has a lot of cases.
The guy was the case on official weapon. He makes courage.
I was saying, that's what I think you got on different times.
Yeah.
That's what happens. I got another guy that out back on the road. We've done 5 years on same crime, different.
I heard 2 games. We have to go on to two rights. Once we won't get
So is it came up as a first one or?
no, so we're starting with we're start with their case on
Yeah.
yeah. Yes, we're gonna start with and then corrections start with that with Christian from it. Why is it down there and no, so one of them down, so we had some ends. That's the only thing with the corrections all the way at the end.
Oh, wrong. My bad. Gotta go to the time. I mean, every name of every.
Yeah, that's
It has to be one. Why would you care?
Are these the private driving? These look like misdemeanors. Yeah, these are the misdemeanors. Those two ones. On Tuesday. I lost it. Yeah, that's most. As we get to.
Could someone maybe?
You may see that.
Thanks. Good afternoon, how are you?
I'm all right. I'm here.
So could you try again? This is turn off. Maybe
What?
I hope you're just.
No, not.
There's one. Yeah.
If you don't do dependency work, it's Greek, right? It's all.
Why Junior, they can't know I'm talking about Julie. I have to review the calendar. Let's start on page 4.
Yes, I'm.
All rise and raise your right hand.
Todo el mundo de pie, levante la mano derecha.
I'm gonna start here.
Please raise your right hand. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Say I do.
Ahora levante la mano derecha, juran o prometen que el testimonio que van a presentar va a ser la verdad, únicamente la verdad, solamente la verdad.
Thank you. Please be seated.
Gracias, tomen asiento.
I do the proposition soon.
Good afternoon.
Buenas tardes a todos.
First case is Christian Fernandez. Do we have any cases with private counsel here?
We have one.
Do we have?
Judge, this is Attorney Evan Hoffman. I asked for a case to be pulled out. This is for Nicholas Robinson. There we go. I can see you, Judge. Good morning.
Good morning. I don't know if they brought your client out though. What's your client's name?
Nicholas Robinson. Nicholas Robinson.
One moment.
Thank you.
Okay, I have another attorney, another private attorney in the courtroom. I'm gonna call his case first. I think they have the defendant, correct? Javarus Antoine Lewis.
Good morning, Your Honor. Robert Erickson on his behalf. Here in support, I believe it's his mother and his sister, grandmother.
All right, let's wait till he shows up on camera. Is he here? Okay, let me take a look at the arrest affidavit. Mr. Lewis, you're charged with possession of controlled substance with intent while armed, carrying concealed firearm, possession of a weapon while committing an offense, tampering with physical evidence, resisting an officer without violence to his person, and possession of cannabis. Nate, would you like to address probable cause first? Well, first, let me hear if there's any argument from the defense.
So Judge, I believe the state is going to announce a standard bond on count 1 of 5K. Defense has no objection. Judge, on counts 2 and 3, I would ask if the state, Your Honor, would consider the fact that these are essentially duplicative charges. The firearm is going to be captured under count number 1. It's my experience that the state most likely will file count 1 and count 2, but dismiss 3. I have no objection to standard on count 4.
Which is what?
The tampering, Your Honor. I think it's quite evident in the A form.
No, but what's the standard?
I
5?
believe it's 2,500, right, State? It's an F3.
Your Honor, just for the record, Assistant State Attorney Cameron Smoller on behalf of the state would be requesting 2,500 on count 1, 2,500 on count 2, 2,500 on count 3, 2,500 on count 4, 500 on count 5, and 500 on count 6.
So again, Judge, no objection on count 1, no objection on count 4. On counts 2 and 3, I would ask the state and Your Honor to consider the fact that I understand they're not fully double jeopardy, Your Honor, but they govern the possession of the weapon as it pertains to the overall offense. Count 5, Your Honor, the A form merely makes an assertion that the defendant did not abide by willful commands. However, it does not state with specificity what the defendant did not to comply. And count 6, Your Honor, there's nothing in the A form that says that the blunt behind his ear was tested. Therefore, the blanket assertion that it's cannabis, when in fact there are types of, like Delta 8, for example, Your Honor, is a cannabis lookalike that is legal under Florida law. So I would suggest again, Your Honor, there's no PC on 5 and 6. I'd ask for some leniency on 2 and 3.
What's your response to?
He has prior.
Oh, yeah. So let me know what the prior record is.
Yes,
Is
sure.
there nothing pending now? Right?
No open cases other than these. There are, do you want to know all the priors or just the ones that ended in a withhold or a conviction?
Convictions.
Okay. None of them ended in a conviction. There are a few that ended
I'm
in.
sorry, the
withhold.
clerk just gave it to me. So
Okay.
save you some time.
Okay.
Thank you, clerk. No, this is Mr. Fernandez. We're on a different line. We're on Mr. Lewis.
My understanding,
On
Judge, they
page
were all
13.
drug priors and that he does have withholds, but I did not see anything of violence when I quickly reviewed.
When you started out, you said you'd agreed to 5,000 on count one, but I thought I heard them say 2,500.
They did, Judge. Well, when I spoke to the state this morning, they told me that the 5,000 was the standard, but I'm thankful for their, the 2,500. Maybe the state meant an overall of 5,000, given count 1 and 4.
Oh, no, base two. Okay. It's fine.
The arguments on counts 2
Yeah,
and 3
yeah,
and then basically somewhat duplicative because it's a firearm.
Your Honor, the reason I requested 2,500 is because I agree that it's a duplicative charge. So instead of 5,000 to 2,500, I just do 5,000 total for those two counts.
Judge, I would just say the family is going to be paying the bond and they were gracious enough to pay me for my presence this morning.
So in count 3, state, what were you seeking?
2,500 is the standard bond.
And count 4, the tampering.
Also 2,500 is the standard bond.
So the state would be seeking a bond of 10,000.
11,000 would be the total with all 6 counts.
5,000, Your Honor.
What's your argument on the probable cause challenges on, I think it was counts 5 and 6?
Yes, Your Honor. The lack of specificity as to what the defendant did to not obey by a willful command. And then number 6, the fact that the alleged cannabis blunt does not appear to have been tested on the field and therefore cannot assert that it's cannabis.
Your Honor, on the arrest affidavit, it does state, and I quote, "Upon observing this, I immediately ordered the defendant to exit the police vehicle and began issuing verbal and lawful commands. As the defendant refused to comply, I reached into his mouth and successfully extracted a plastic bag containing approximately 40 pills. The pills were identified via investigative means as Percocet mixed with sildenafil with a total weight of 14.1 grams as confirmed by the City of Miami Central District scale."
And again, Judge, it goes from he issued lawful commands to he was prying my client's mouth open with no specificity as to what the non-compliance was.
It does say he refused.
He refused to comply with the command
I
to
don't
exit
believe,
the police vehicle.
I don't believe the statute requires specificity, Your Honor, especially for probable cause. All there needs to be a lawful command, which the defendant refused to follow.
I would say that there is probable cause for each of these counts, based on the standard that we need to meet for this hearing. Further than that, I would leave it up to the prosecuting attorney on the case.
We split the baby, Judge, 25 on 1, 25 on 4, 5 on 5, 500 on 5, 0 on 2, 3, and 6. Total 5,500. He has no history of any prior flight. I didn't see anything about bench warrants. It is to secure his presence, Judge, not to punish him.
What are his ties to the community?
I believe he's resided here his entire life. Born and raised, Your Honor.
So we're just finding probable cause for all of the enumerated offenses. For count 1, let's set the bond at 2,500. Court does find the defendant's arguments persuasive as to the counts 2 and 3. So I'll set. Count two, it'll be 1,250. Count three, 1,250. Count four. This is a third-degree felony, state?
Yes, Your Honor.
$1,250 on count four, and then 500 and 500 for counts 5 and 6.
Yes, Your Honor. Thank you for your time, Judge. Thank you, State.
Make the notes.
They're calling Christian from this next room.
I don't think it's, no, not over here.
It's only, he only has one sewer.
For Dollar Tree, I mean, do we have to put one for each separate case number?
If
Because they're all for Dollar Tree.
for the same one?
Yes, this
No,
is my address. There's multiple cases, but they're all at Dollar Tree.
Then for the Lion Street.
We have the other defendant is represented by counsel. Private
That
counsel.
would be, yeah, that'd be Nicholas Robinson. This is attorney Evan Hoffman. I'm not sure if they brought him up yet.
He's here, Your Honor. He's coming up.
Okay.
This one's
Great. Thank you, Judge.
Dollar Tree.
I have David Solomon, Your Honor, if he's available.
Oh, sorry, what happened with Mr. Fernandez?
No.
I missed that. Sorry, what happened with Mr. Fernandez?
Nicholas Robinson is an added charge.
Yes, Judge. Attorney Evan Hoffman on his behalf.
Okay, just one moment. I gotta get his A form.
Okay.
What's his name?
Oh, is this Nicholas Robinson?
Yes, Nicholas Robinson.
Nicholas.
He is on page, I think 16 or 17. He's on 16.
So that's not him.
And again, Judge, attorney Evan Hoffman on his behalf.
That's the one.
It's in that column. You have later on.
This one, I'm sorry.
Okay, that was the out of turns, no corrections wanted.
It's not fair.
Yes.
I believe, Your Honor, this is an add charge that looks like it's duplicitous to what we've already addressed.
It is an added charge, Your Honor.
Right. So.
Yeah. DUI manslaughter, correct?
Correct, Judge. And he's already has a bond on vehicle homicide, reckless manner. We were here last week when they added the charge again. This seems to be completely duplicitous. He has a $200,000 total bond. This is his third magistrate. I would just ask on this charge, since there already is a $200,000 bond, plus level one, plus he can't leave Miami, that we just set a dollar bond on this case. I mean, this is just, besides, I believe, double jeopardy. It seems it's completely duplicitous to case number F253885, which the magistrate judge found put a $100,000 bond on him with the same charge, vehicular homicide, reckless manner. Same facts, same circumstances, and you can't have, both charges on homicide for the same issue. Manslaughter, homicide, it's the same act. So he already has a $200,000 bond set, plus most stringent house arrest, plus he can't leave Miami. I would just ask that a dollar bond be set on this, and then Judge Young is the assigned judge. If and when we decide to do a bond reduction or bond hearing, he could decide any other conditions.
Okay, let me
There's
have a
no
chance.
change in circumstance.
I have not reviewed the arrest affidavit in this case yet. This is case number F-25-482.
Okay.
There is also, the state just handed me a motion for pretrial detention pursuant to section 907.041. Have you seen their motion?
I have not seen it, and I would ask that the court not rule on this and let the division judge, Judge Young, handle it. It's the weekend. I'm not available to read the motion. I understand what the rules read, that, you know, we need a couple hours notice, but it is on the weekend. It's not during a weekday. He's had this bond set. There is no urgency to this motion for pretrial detention. Without me being able to investigate this, I will let the court know that tomorrow I'll be at a funeral for a friend's father. So I would ask if the state wants to do a pretrial detention motion, file it in division and let the division judge, which is Judge Young, handle this.
All right, well, like I said, give me a minute to review the arrest affidavit right now so I can address this case as a standalone case.
Yes, Judge.
Right, the charge as alleged is DUI manslaughter. Is there anything you want to address in terms of probable cause for this, counsel?
Judge, I've read the original police report. I don't believe we got the, unless there's something different where they got the blood results back. I haven't seen any updated information unless there's an updated A form, which relates to blood results. I don't have any other information, Judge. So if there was a supplemental police report that mentions the blood results, I would ask the court to advise. If not, then no, there's no other probable cause arguments.
It says the officer observed the defendant with an odor of alcoholic beverage coming from him. He was asked to provide a consensual blood sample, but refused. The officer observed signs indicating the defendant was under the influence of alcohol, such as bloodshot, watery eyes, odor of alcoholic beverage coming from his breath. The evidence was they observed the car traveling at approximately 100 miles per hour in a posted 40 mile per hour zone.
Your Honor, on the next page, it does what the blood alcohol levels were.
Oh, it does. Okay.
And I also included the report with the motion that was provided to from the prosecuting attorney. I don't know if Mr. Hoffman has reached out to her regarding that.
No.
Provided from her to me.
So right. The last page of the, actually page 7 of 9, the arrest affidavit says there were at least 3 blood draws. The first one was a 0.192 grams per 100 milliliters blood. The second one was 0.131 grams per 100 milliliters. The next was 0.111 grams per 100 milliliters.
So, Judge, can you repeat those one more time? I apologize.
Yes, the three blood draws were 0.192, 0.131, and 0.119.
And 0.119?
Yes.
Okay, so it looks like, well, that's interesting. It looks like the first one is definitely out of range with the second and third, within the variance of an 020. 131 to a 192 and a 119 to 192 definitely leaves some issues for defense, which we'll explore. But again, Judge, I would ask that any pretrial detention motion be set with calendar. It is a Saturday. It's not a working business day. I would ask that the bonds that he already set, because there is already a vehicle or homicide bond set at 100,000. I would ask that no additional bonds be set at this point. $1 bond. The total bond is $200,000 aggregate for everything. Plus, like I said, the total house arrest, total lockdown, and he can't even leave Miami. So, Judge, at this point, I would ask that just $1 bond be set. We could address any other pretrial detention issues on a working business day, where evidence could be provided, where we could subpoena the officer, the state could subpoena the officer. And like I said, Judge, knowing that one of the samples is not within range of the other two, we will obviously be doing our own investigation. So I don't think adding any more to a $200,000 bond at this point. Actually, I think it may actually be double jeopardy because the charges are the same. It's one's vehicle homicide, reckless manner. The only thing changes, they got the blood results back. But they already had the intention of this being a DUI case when they set the bond at $100,000 last week. So I would ask that no additional bond be set, just $1 bond, Judge.
Well, counsel, all I can do is look at what's in front of me, and there's probable cause based on the low standard for probable cause. Is it more? There is probable cause for the DUI manslaughter charge, which is a second-degree felony. So for this case, state, aside from the motion for pretrial detention, which what is the bond on this? The second-degree felony DUI manslaughter.
Well, Your Honor, we're trying to hold them no bond.
Yeah.
But this is a bondable offense, is it not?
It's an
Your Honor, per the statute on the motion, the felonies that are listed there, including DUI manslaughter, are eligible for pretrial detention. The time for that motion to be filed is during the first appearance. The defense can appeal that. They can also special set an Arthur hearing, which would be the time to address the judge.
No, incorrect. Arthur hearings are not for these type of charges. Arthur hearings are for first-degree punishable by life cases. This is not an Arthur hearing case.
State, explain the motion that they just filed and served right now. In fact, the certificate of service is not even signed.
Sorry, I can sign that right now.
So you haven't served this on counsel yet?
No, Your Honor, we usually present these motions for the first time during bonds to the judge. I've never had an issue with not presenting it to defense counsel before. And it's also per statute, there's no specific factual basis that is included within the motion that defense counsel would need access
Do you have a
to.
copy of the statute?
I can say the statute is
No, do you have a copy of the statute?
not physical, but I think it pretty much says exactly what's in paragraph 2 of the motion.
It's a
From section 5A of the statute is the section that applies here.
Okay, let me see the motion.
And I should be entitled to reasonable notice for the hearing and for me to be able to present the defense to a pretrial detention on a case that's a second-degree felony, just so the record's clear and the state understands. I know they're probably not felony prosecutors, but Arthur hearings are for first-degree punishable by life felonies. where you're not entitled to a bond by normal standards. So this should not be an Arthur hearing.
The state has handed me the motion back. Okay, the first paragraph says, the offense for which the defendant is presently charged is a capital felony, life felony, or felony of the first degree.
Judge,
That's not applicable here, is it?
Judge, DUI manslaughter, if I'm reading from Florida statute 907.041, subsection 5, pretrial detention, subsection 10. As used in this subsection, dangerous crime means any of the following. And number 10 is manslaughter, including DUI manslaughter, which the defendant is currently being charged with. While it's not a first degree, like the statute says, it's included in the crimes that can be used in this motion.
You don't have a copy of the statute.
No, Your Honor.
I could give you my laptop if Your Honor would like.
Judge, good morning. Assistant Public Defender Madeline Brown. Just as a friend of the court, the statute is very clear that there's an enumerated list of dangerous felonies, and your inquiry is twofold. So it's one, does the offense fall into that enumerated list of dangerous felonies? If so, two, is it a capital felony, a life felony, or a first degree felony? Even if it's an enumerated crime, it may not be a first degree felony, in which case then the pretrial detention motion is moot. It's not, the state has no basis to file it.
Well, it's not moot, it's not applicable, you're saying.
Right.
Judge, can we pass the case for 3 minutes? We're calling the
counsel. I'm gonna have to pass the case. Okay.
All right, Judge, I'll be waiting on Zoom. Not a problem. Thank you.
Judge, can I call a case?
What's this defendant's name?
Who's that?
David Salmeron.
I'm sorry, who's talking? Okay.
Leonardo Conception, Your Honor, on behalf of David Salmeron.
I have to give the clerk a minute to find the case.
Of course, no problem. He needs an interpreter.
Your Honor, the defendant is also out on misdemeanor probation. M24025-460.
Counsel, this is interpreter's case, right?
Yes.
Got it, thank you.
All right. David Salmeron.
Señor David Salmeron.
Is that him before the court?
I believe so.
Is that your client, Mr. Concepcion?
I believe so. I'm on my phone, so it's hard to see the little picture, but it looks like it.
Okay, Mr. Salmeron is charged with unlawful or false bill of sale, a vehicle with altered ID, and there's a hold. Let me take a look at the arrest affidavit.
Señor Morán enfrenta un cargo por tener un recibo de venta falsificado y por haber alterado la identificación de un vehículo.
And Your Honor, good morning again. Just as a friend of the court, I know counsel probably doesn't have a copy of the arrest affidavit, but I know it's very lengthy, so I would just like to direct your attention to the fact that I believe there's a statute of limitations issue here. The alleged crime occurred November 17th of 2021, which was 3 years and 4 months ago. And
okay, on page 3 of like an 11-page arrest affidavit. So,
entonces se dice que ese es un caso en el que la limitación de los estatutos aplica. Eso es una situación que presuntamente ocurrió el 17 de noviembre del 2021, o sea, hace 3 años y 4 meses.
Mr. Concepcion, have you had a chance to read the arrest affidavit?
Yes, I do have a copy of it, Your Honor.
Okay. So since you're on counsel, are you counsel of record then for Mr. Salmeron?
No, I'm coming for Mr. Jay White, who's going to be doing the case, but he was out of the country today, so I'm covering this hearing for him.
Este abogado está, de hecho, cubriendo por el otro abogado que está fuera del país. El abogado que está ahorita presente es el que le está cubriendo porque el otro está viajando.
Is there anything you would like to argue about probable cause?
Well, Judge, I did notice the same issue with the potential issue with a statute of limitation problem based on the four corners of the arrest affidavit. So that is the one issue that I would bring to the court's attention.
El abogado defensor quiere mencionarle al juez de la situación, la misma situación de del límite o la limitante con los estatutos en cuanto a la antigüedad del caso a la luz de lo que aparece en el informe del arresto.
Where's the date of the offense? Because I'm looking at page 1 and it says that the violation of law occurred March 3rd, 2025. So.
Bueno, el quebrantamiento presuntamente ocurrió el 3 de marzo del 2025.
Yes, but the purchase of the vehicle, I think, relates back to the 2021, which may be the issue. And that's on page, I believe, 9 of the report, refers to the purchasing of the 2019 Ford F-250 on November 16th of 2021.
Bueno, lo que tiene que ver con la compra del F-250 del 2019, eso ocurrió el 16 de noviembre del 2021.
All right, State, what's your position on this case?
¿Qué piensa la fiscalía del caso?
Judge, it seems like a statute of limitations argument is more akin to not in first appearance. If anything, through the four corners of the A form, there is probable cause to believe that this alleged offense occurred. Based on my review of the A form, I feel like if it's going to be a statute of limitations argument, let's move into after, maybe at arraignment, but in first appearance, we're here to determine probable cause. There's probable cause that this offense occurred, and therefore the state would just be asking for standard bond of $2,500 on each count.
Señoría, dado que la situación del estatus de limitaciones es algo que está involucrado aquí, pensamos que eso sería un asunto que pudiera ser abordado mejor durante la lectura de cargos, dado que esta audiencia es solamente para la primera comparecencia. Por ahora pediríamos una fianza de $2,500 por cada cargo.
So the standard bond is $2,500 for each?
Correct, they're both third-degree felonies, Your Honor.
Exacto, los dos son delitos mayores en tercer grado con fianza de $2,500.
All right, Mr. Concepcion, you want to address bond?
We would be agreeable to the standard bond, Your Honor. We would ask that the hold be released from his probation. That's a misdemeanor case related to a boating accident. It's nonviolent. There's been no reports of him missing court dates, so I don't think a hold would be necessary on this case, but we would be agreeable to the standard on the amounts.
Estamos de acuerdo con la fianza estándar. La situación, lo que ocurrió fue una situación, un incidente en un bote, en una embarcación, pero no es un delito violento.
Your Honor, I'm also showing an be a hold on the card.
Pero aparece una orden de retención para demostrar los fondos de dinero en la tarjeta carcelaria.
Police officer. I mean, the state has the authority to do what they want. They're the prosecuting authority. So if they're agreeing to the standard bond, and they're agreeing to the standard bond, but what is the hold for magistrate?
That's you, Your Honor. You're the magistrate.
I know what that means. Thank you. I mean, what is the underlying case? I don't have it. Is it a Miami-Dade case?
Yes.
How old is the case?
24. He closed it out on November 2024. He took a year probation on the case. Clearly, this falls within the time frame. So he's violating probation based on picking up this new felony.
El caso subyacente fue un caso de delito grave del 2024. Tenía un año de libertad probatoria y quebrantó la libertad probatoria con este caso de delito menor.
Okay, I'm going to find that there's probable cause. Obviously, the issue of statute of limitations can be addressed at another date if appropriate. I'm going to set the bond for count 1 at $2,500, count 2 at $2,500. I'm not going to issue any type of hold on a misdemeanor case.
Entonces, el motivo fundado para el arresto, fianza de 2.500 para el primer y segundo cargo. No lo voy a tener retenido por el caso del delito menor.
Your
Thank
Honor,
you.
no Nebia hold as well?
I'm sorry?
No Nebia hold as well? I'm showing a Nebia hold on the jail card.
Yeah, that's something that the detective wrote. The state attorney is here as the prosecuting agent for this case, and they're saying, no, they're not asking for a nebia. So
So no Nebia requirement.
no nebia required.
No le requieren que tener el tipo de audiencia tipo Navia para aclarar la procedencia de los fondos.
If the state agrees to waive that, then they're waiving it. So
Judge. We'll ask for a Nebia hold then, given the.
no, you've already agreed to waive it. Come on. You can't go back and forth like that.
That's
Come on.
fair enough.
All right.
Thank you, Your Honor. Have a good weekend.
Too.
Thank you, State.
Your Honor, regarding Nicholas Robinson case, I did speak with the prosecuting attorney, and I just wanted to let you know that she is going to be joining the Zoom to address the bond, and her name is Laura Adams. So I don't know if she's gonna pop up, but
You need a copy of the statute. Someone has to get me a copy of the statute.
I'll bring it up.
And I'm still here, Judge. This is Mr. Hoffman. Unfortunately, I'm out and about. I got notice late on this, so I don't have a copy of the statute, but I'll defer to the court and I'll speak with Ms. Apple when she gets on.
Do you want to speak to her off camera?
I could put my.
Your Honor, she's on the Zoom.
I don't know if who's running the Zoom. They could put them in a breakout room.
The attorney's name is Laura Adams.
Who is my AV tech helping out?
Judge, they don't do breakout rooms here in bond hearing. It's not set up that way.
Well, I'm going to ask the AV tech. Can we do it? No. Okay. Well, how about just a regular phone call?
Good afternoon, Your Honor. This is Laura Adams. I'm the chief of the Traffic and Vessel Homicide Unit at the State Attorney's Office. I can try to reach out to Mr. Hoffman. I don't know if he's able to put his number in the chat. I'll be happy to speak with him on the phone.
I will.
Please.
And let me put my office number on the chat.
I'm happy to speak with you. I just don't want to put my number on the chat, but if your number is
I
listed-
know. I just put it on, Laura. Did you see it?
One moment, please. Yes, I do. Your Honor, thank you so much. If you could just pass this moment for a few moments, I can speak to Mr. Hoffman.
Take whatever time you need.
Thank you, sir.
Thank you. Okay. All right.
Okay.
Anybody else? This is correction since I asked to call out.
Christian Fernandez.
Your Honor, he refused, reset for tomorrow.
Yes, what is the PD's name?
So I have to write refuse on all of these.
Well, just whoever refuses.
Where do I do
If the
that?
APD could please introduce herself for the record.
Good morning, Assistant Public Defender Madeline Brown.
What is 3-8, right? Then it's refused.
Or do you still want it?
That was all Mr. Fernandez, right? You want me to call them by A form or? Because I have printout, prior printouts, but
No, I think I
You-
mixed it up. Is it Nicholas Robbins?
Nicholas Robinson, we passed.
Alvaro Aramillo.
Alvaro Jaramillo. Alvaro Jaramillo.
Okay, Your Honor, he refused reset for tomorrow as well.
Okay,
We should have them.
I think it's one of yours.
I'm gonna reset it for tomorrow.
You repeat court?
Yeah, refused to.
Perfect.
Jeffrey Hepburn.
Ward D, reset for tomorrow.
You said again?
Yes.
It was already a finding of probable cause yesterday,
Interesting.
so
This one. Oh, then this one. Let me make sure it's not my certificate.
do it reset to tomorrow.
Attorney.
How many times do you reset before you just say no? And set the bond or send it to the
It's
division.
when they waive their appearance, Your Honor, at some point, they'll probably get tired of resetting and they just waive their appearance.
I put my name here.
West Lines?
No.
It looks like something from the 80s.
By sure.
Where's that other name from me?
It's here.
Robert Barotto.
Baroto.
Baroto also refused reset for tomorrow.
It's better with detaining, that's why.
Your Honor, all of the defendants are from out of facility. So when they're sitting here waiting for bond hearing, they want to leave when transportation comes. So they're here from 8 o'clock this morning.
So they went back with transportation, is that why?
Yes, that's correct. They no longer want to wait anymore.
PD, did you have a chance to talk to them before they say, I want to go back, or
I did not, Your Honor, but one of our paralegals did, I believe.
I assume they were advised of the consequences of delay? All right. Brandon Lee Neely.
Refuse, reset for tomorrow.
This is for you. Oh,
Yeah.
Yep.
So just throw it in.
hold it.
You don't want to jinx.
Sorry, I'm not super sleepy.
I am.
Just a little.
Now I have, okay, this doesn't match up to the A fund. Oh, never mind, it does. It says Tony Kane.
Mr. Kane also refused reset for tomorrow.
Hey, you're jinxing.
Was
They do realize that they lose an hour tonight, right? Less sleep tonight.
oh, that's why they call it springboard. I see. Springboard
And fall back.
and fall back. Get lunch.
Timmy Williams.
Williams also refused. You're on the reset for tomorrow.
They don't care. Already. Yeah. we can work. You assuming?
Devon Givens.
He's coming up, Your Honor.
Okay.
He's right here.
Okay, Mr. Givens, you're charged with battery by strangulation, criminal mischief, and domestic violence battery. Give the court 1 moment to review the arrest affidavit.
And Judge, would you like me to let you know before you read it if I have a probable cause argument, or wait till you're finished?
Please let me finish, and I'll let you know. Okay?
Here we go. Yeah.
Okay, I'll hear from the defense attorney regarding probable cause.
Yes, Your Honor, just as to count 2, the felony criminal mischief, $1,000 or more. I believe you can only find probable cause based on this arrest affidavit for 2nd-degree misdemeanor criminal mischief because there is no amount provided for any damage or for value for the windshield that Mr. Givens allegedly broke. So where there is no value listed, the most you can find in terms of probable cause is a 2nd-degree misdemeanor.
That's correct, Your Honor.
Okay, so they stipulate.
Yes, Your Honor.
All right, so the court does find probable cause for the felonies. I'm sorry, felony count number 1. What is this bond state?
For count 1, it would
$2,500, Your Honor.
And for criminal mischief as a misdemeanor, the bond would be what?
500, Your Honor. And for the misdemeanor DV battery, it'd be $1,000.
Okay, any argument from the defense on the bond amounts?
No, Your Honor, we'll agree to the bond amounts.
Okay, so bond will be $2,500 count 1, $500 count 2, and 1,000 on count 3. In addition, the court will be entering a stay away order. Mr. Givens, you are to have no contact with the alleged victim. I don't think I have a name.
It's initials, Your Honor. It's Marcy.
SM. Okay.
Yes, sir.
All right. You're also not allowed to have any firearms, weapons, or ammunition. You're prohibited from contacting SM in any way while this case is pending and this order is pending.
Yes, sir.
Pardon me, Your Honor, I don't mean to interrupt, but just so the court knows, Mr. Hoffman and I are back on the Nicholas Robinson case.
Yes, Judge. We're ready as soon as you are, Judge.
I'm actually not ready. I asked
Okay.
for a copy of the statute and no one has been able to provide me with it yet.
Yeah.
Well, Judge,
Judge,
we're
I
going to make
can-
this easy for the court. We're going to make this very easy for the court. We've come to an agreement. So the court's really, I get the court wants a statute, but I think we've come to an agreement on this.
Judge, I can give the court the statute. It's 907.041. It's
Right.
on
Have the statute. You know, I'm kind of old school. I like books and paper, but
I'm the same, Your Honor. I just had my 31st year at the state attorney's office yesterday. I love
but anyway, if there's an agreement as to bond and probable cause, let me know.
Yes, sir.
Wait.
My understanding is that the defense is going to be at this time stipulating to the court holding the defendant on pretrial detention pending a decision by Judge Young on Monday. If the court would put this case on Judge Young's calendar for Monday, then we will go before the judge. I will probably file a supplemental motion for pretrial detention, laying out the grounds that the state is seeking this, and then we will address it before Judge Young on Monday.
That's correct. So we're agreeing to the pretrial detention. So there's a hold on him. When we go in front of Judge Young, we're not making any admissions on the factual determination of the motion. We're just saying we're agreeing to the pretrial detention now. Judge Young will be the ultimate arbiter whether or not the pretrial detention will stand or will be vacated or addressed with some sort of bond conditions. Right, Ms. Adams?
That is correct, Judge. I'm not binding the defense to this agreement. I am understanding that this agreement is temporary, pending a litigation before Judge Young.
Okay,
Correct.
and corrections, is it okay if I say that the defendant has agreed to pretrial detention pending the hearing in front of Judge Young on Monday?
Yes.
So reset in front of Judge Young Monday. Thank you both for.
Thank you, Judge.
Thank you, Ms.
sir. Have a great afternoon. Take care. Thank you again.
Have a good afternoon. Bye, guys. Thank you.
Wait, the clerk is saying that I have to set a bond.
That's not correct, Judge, because the DUI manslaughter charge, the court can order him held with no bond because pretrial detention has been conceded to by the defense.
So they're conceding to detention, no bond.
Correct.
We're pending
Hearing on the
being in
motion.
front of Judge Young. Correct.
Good.
Correct.
So he
That's correct.
no bond until the hearing.
Yes, sir.
Correct, Judge.
By
On
agreement
Monday.
of the parties, I'm granting the motion.
Correct.
Okay.
Judge.
Thank you.
Okay. All right. Thank you, Judge.
They can have this back, but thank you. Twenty 23. Thank you, corrections.
You're welcome, Judge.
Can I go to this pile now? Absolutely. I apologize. I'm just going to add, and by agreement of the parties. Because the defendant's counsel agreed to the pretrial detention. Carla Connolly, Ms. Connolly, you're charged with child abuse.
I prefer Spanish. Judge, she prefers Spanish. I apologize.
I'm sorry.
She prefers Spanish, if we can have the interpreter.
Thank you.
Tell Ms. Connolly she's charged with felony third-degree child abuse.
Señora, se enfrenta a cargos por abuso infantil, es un delito grave en tercer grado.
Any arguments as to probable cause defense?
El juez pregunta si hay algún tipo de defensa por motivo fundado.
No, Your Honor, I'm just asking if that you would consider pretrial services with an alternate bond of $2,500.
No, señoría, estoy pidiendo si su señoría tiene bien concederle el servicio previo al juicio como alternativa a una fianza de $2,500.
Judge, given the allegations, we'd be more comfortable with standard bond and not PTS of $2,500.
Señoría, dado la gravedad de los alegatos, preferimos que su señoría le concede la fianza estándar en lugar del servicio previo al juicio.
Doesn't look like she has any prior convictions, correct?
It doesn't, Your Honor, but it's involving a minor child.
El juez pregunta si hay algún tipo de antecedente penal. La fiscalía responde que sí, pero que involucra a un menor.
Do you know where the child is now?
¿Sabe dónde está el menor ahora? Pregunta el juez.
We just got the arrest form this morning. I'm not sure about the whereabouts of the child right now.
Esta mañana fue que nos dieron el informe del arresto. No sabemos nada acerca del paradero del menor.
Defense, where would she be residing if she was given either bond or, well, she's getting a bond, but if she was given pretrial services, where would she be residing?
El juez pregunta si, aunque yo sé que le van a dar fianza, pero si le fuesen dado el servicio previo al juicio, ¿dónde residiría?
Judge, she would be returning to her address unless that is the address that is currently listed for the alleged victim, in which case she would not be able to return to that address and wouldn't be released until she provides an alternate address.
Señoría, ella regresaría a la dirección donde reside, a su residencia, a menos que ahí sea donde reciba el menor. En ese caso, no sería puesta en libertad hasta que no proporcione una dirección alternativa.
That was, I guess, my question in a roundabout way. Does she have an alternate address?
Bueno, tal vez la pregunta en realidad era esa. ¿Tiene una dirección, otra dirección, una alternativa?
Judge, she believes that she can get an address for a friend or a family member.
Señoría, ella cree que puede conseguir una dirección donde un familiar o un amigo.
Well, correction says she does qualify for pretrial release, finding that she has no priors. I'm gonna find PC, grant pretrial release with the alternate bond of $2,500. Obviously, this is all subject to her being verified with an address that she's not in contact with the minor child.
Dado que no tiene antecedentes penales, entonces le puedo conceder el servicio previo al juicio, hallo que hay motivo fundado para el arresto. Como alternativa, se le concede una fianza de $2,500, con tal de que no tenga contacto con el menor y de que pueda verificar una dirección.
Because as a condition, I'm also entering a stay away order with a minor RT.
Y como condición de excarcelamiento, voy a presentar una orden de alejamiento que le impida acercarse al menor cuyas iniciales son RT. Iniciales.
Till this case resolves and the division judge does something with the stay away order.
Y ya entonces en últimas, la juez de la división tomará una decisión en lo que tiene que ver con la orden de alejamiento.
Thank you. Tamia Wanika, Patterson.
Good afternoon.
Good afternoon. It is afternoon. I have two cases. The first one, Ms. Patterson, you're charged with aggravated battery and simple battery. Let the court review the arrest affidavit.
Your Honor, I'm currently filling out the stay away order for that case.
Any argument to probable cause?
Yes, Your Honor. And just so you're aware, I'm going to make a similar argument for her second case as well.
Okay.
But it's my position you can only find probable cause for a first-degree misdemeanor battery. There is no allegation that a deadly weapon was used. They only allege a phone, and there were no allegations of great bodily harm to the alleged victim, nor were there any allegations of permanent disability or permanent disfigurement. All the A form mentions is bruising under the eyes and a laceration on top of the head, but there's no indication how large that laceration was. The arrest affidavit does not state that he needed stitches or that he needed any medical treatment at all.
Well, it does say a metal lamp was used to strike him in the head.
And as for the metal lamp in the second case, it doesn't state how it was used. It doesn't describe the lamp, whether it's like a long stick type lamp or a small table lamp. And similarly, in that case, the alleged victim had no visible injuries and did not require any medical treatment. There were no allegations of great bodily harm, permanent disfigurement, or permanent disability.
Anything you say on this case, which is 25-4779.
One second. Yes, sure. Your Honor, I'm going to argue that the metal lamp could be considered a deadly weapon that could cause great bodily injury, and therefore would meet the requirements for aggravated battery.
Your Honor, also within the four corners of the A form, the defendant texts the victim admitting that he hit her. No bruised baby can't go with no evidence. Quote from the arrest affidavit.
And Judge, I have not argued no probable cause for battery. We'll concede there's probable cause for battery. So the text message is really immaterial at this point, but as it relates to the lamp, it's not whether this item could be used to cause great bodily harm. The statute is aggravated battery can occur one of two ways. One, it's with a deadly weapon, which again, I am arguing the lamp is not. And two, there was great bodily harm, not whether there could be. And a deadly weapon by statute is defined as an item that in its normal course of use could result in death.
I would say that a metal lamp could be classified as a deadly weapon, and I think that specific of an argument is something to take up beyond the first appearance.
And she also threw a wooden chair at him, Your Honor, as well. Like, it wasn't just the lamp, there's multiple possible objects.
And I understand what the state is saying, but none of those possible objects were deadly weapons.
Let me just look at the statute real quick.
The statute is 784.045, Your Honor.
Is there a definition section for deadly weapon?
No, it just uses a deadly weapon.
Well, for purposes of probable cause, I'm trying to find this probable cause. So what is the
Judge, were you finding probable cause for the lamp allegation or for the other allegation in 4780?
Finding that there's probable cause for the aggravated battery, not only because of the lamp, but I think there was a chair that was thrown.
That's correct, Your Honor.
Okay, so probable cause.
There's like multiple objects thrown at the alleged victim here.
Right, there's two separate cases.
But are they? This occurred in May?
One of them occurred in May 2024, one of them occurred in October. We're in the May one, Your Honor, if I'm not mistaken.
We kind of addressed them together. The first one from October of 2024 was the one with the phone.
Defense counsel, I apologize. Could you talk a little bit closer to the mic? I think we're having trouble hearing you.
Yeah, counsel.
Sorry.
Hear you.
Sorry, is this better?
That's better, thank you.
There's the October allegation. It involves the phone, which I suppose the argument is the phone is a deadly weapon, which I argue it's not. And then the second case ending in 4779 is from May of 2024, and that's the one with the lamp.
Okay, well, I'm finding probable cause for the lamp. So the standard bond for Agbat
is $2,500, and then for regular batteries, $1,000, Your Honor.
All right, so count one, $2,500, count two, $1,000. I'm also entering a stay away order for the alleged victim, LP. Is that it?
Yes, Your Honor.
Apparently the victim's name is in the A form. You can't put it in?
Well,
When we send it, when we send it through discovery, we redact it.
Your Honor.
The victim's brother anyway. Allegedly. Okay, you can't have any contact with your brother, Lawan Patterson, until this case is resolved and the stay away order dismissed.
Your Honor, she has another case.
I know, I'm gonna get to it right now. Okay, so the next case is 254780. Also aggravated battery on the alleged victim is, let me see.
Same person, Your Honor.
I don't think so. It's Mr. Clemson. Different victim.
Clemson.
This is not the brother,
No.
is it?
No, it seems to be a different one.
Someone took the liberty of underlining Mr. Clemson in the arrest affidavits. Who did that?
Okay.
Well, this is a little curious to the court why these incidents that occurred so many months ago are coming to light just
It's
now.
because they don't arrest her at the time, Your Honor, possibly because she fled, and then this is the reason these again are 2025 cases, because the case number is based off when they're arrested, not when the incident occurred.
No, I understand.
Yeah. Sometimes people are hard to find, yes.
Any argument is probable cause on this case, counsel?
Yes, Judge, this was the allegation is that I suppose the allegation is that a deadly weapon was used, but I argue that there's only probable cause for a first-degree misdemeanor battery because the item that was used was a phone, which is definitely not a deadly weapon, and there are no allegations of great bodily harm, permanent disability, or permanent disfigurement to the alleged victim. The arrest affidavit only says there was bruising under the eyes and a laceration on top of the head, but it does not indicate how large the laceration was, and the arrest affidavit does not state that he needed stitches or any kind of medical treatment at all.
Well, court finds sufficient probable cause to allege a laceration, which could leave a permanent scar. We don't know, but
And Judge, we'd be asking for standard again, which
$2,500. $2,500 bond on this case, a stay away order against the alleged victim, Fred Clemson. FC in the order. You're to have no contact with Mr. Clemson, Ms. Patterson,
Yes, sir.
until this case is resolved and the stay away order dismissed.
And I'm sorry, Your Honor, if we can just address something real quick with Ms. Patterson. So she is a corrections officer, as is Mr. Clemson. They work in the same facility. What is it? Is it Metro West? They work state corrections. So
They work together in the same facility. So let me see the stay away order. And see if I can modify it.
Your Honor, number 6, the defendant is allowed to have contact with the victim, but is prohibited from being physically threatening or violent towards the victim in any manner whatsoever. If you initial next to that, I will modify it for peaceful contact.
Well, that's initially every one of these. So.
Oh. No. You're supposed to be writing NA or nothing.
Would you do me a favor, State? Can you write another one? I'll clear this up and I'll start over.
Yeah,
sure. Hold on. Don't let Miss Patterson go yet.
They want.
What?
What for what?
For what?
Okay,
Okay, well, is he on Zoom?
we weren't notified of anything, so I'm really not aware of why he's here. I don't even understand.
I think they gave a jail number or a police case number.
You want to just fill out the stay away order and I'll do it over?
Yes.
I've been.
Oh, God.
You said they're state corrections officers, not county?
yes, that's correct.
Do they both work the same shift or can they change their shifts? Can she change her shift?
I got my shift changed already. Because of this.
Not the same shift.
They're not the same shift.
Right.
So if the mic is off.
This is on the alleged victim, Mr. Clemson, correct?
It's Mr. Clemson, yes. And Judge, the issue is, I guess their shifts may overlap and they might incidentally make contact while.
Okay, so I'm still checking the box that says no weapons.
Judge, as it relates to weapons, I'm not sure what exactly the stay away order says, but she's required to carry pepper spray as a corrections
For her
officer.
job?
Pardon?
For her job.
Yes, correct.
Okay, I'll put except as required by employer.
Thank you.
That means you can only have it at work. So, counsel, I'm sorry, they don't work together at the same shift.
They work together at the same facility, but not at the same shift. However, they may cross paths when leaving during shift change.
Well, I'll cross out the part that says that you cannot, the place of employment. Because it says you're prohibited from contacting indirectly the person.
No, Your Honor, you can just sign the number 6, and that way they're allowed to have peaceful contact.
Okay. The state agrees to that, but not so. Okay, they're allowed to have peaceful contact. Okay.
Thank you, Judge.
Diana Figueroa Matute.
And Judge, she will need the Spanish interpreter, please.
Interpreter present.
Good afternoon, ma'am. You're charged with an aggravated battery.
Señor, usted enfrenta cargos por agresión física con agravantes.
The argument to probable cause.
Yes, I'm sorry, I'll let the interpreter.
Un momentico, la abogada va a buscar si hay un argumento para motivo fundado.
A similar argument to the arguments I just made relating to the aggravated battery. I'm arguing that the metal cup with the Mercedes-Benz logo is not a deadly weapon.
La abogada, perdón, argumenta que el golpe con el vaso metálico con el logo de Mercedes no constituye un arma contundente, un arma cortopunzante más bien.
And similarly, there was no indication of the requisite injuries to allege an aggravated battery based on great bodily harm, permanent disability, or permanent disfigurement.
Y tampoco hay nada que indique que eso constituye algún tipo de desfiguramiento o que constituya algún tipo de agresión con agravante como tal.
And while there was a laceration alleged, it again does not say how big it was, whether it required, well, I believe it says it didn't require transport to the hospital, and therefore no stitches.
Y aun cuando se dice que hubo una cortada, no se indica qué tan grande era, ni tampoco que haya tenido que ir al hospital o que se le hayan tenido que tomar puntos.
Okay.
Judge, we already know a previous argument from the last one, and at this, Your Honor just found that a metal lamp was enough for a deadly weapon, and Your Honor also pointed out that there was a laceration, and that was enough for probable cause for the other one. So for that,
Señoría, decimos que nuestro alegato es de que la lámpara metálica sí constituye un arma cortopunzante y que state for interpreter the last thing what you said, please. I'm sorry, I missed that part.
I was saying that the judge had already found probable cause for when there was a laceration on the other case, just like this one. And
Got it, thank you. Entonces, así como el caso anterior, el juez ya halló que había motivo fundado para ese tipo de cargo con ese tipo de elemento, el cual de hecho sí ocasiona una cortada.
And because all that is present in the A form, in the four corners of the A form, there's enough for probable cause in this case.
Y debido a que todo eso aparece dentro del informe del arresto, alegamos que sí hay motivo fundado para este arresto.
All right, the court does find probable cause. The laceration could mean stitches. It could mean a lot of things.
Este despacho halla que sí hay motivo fundado para este cargo, puede incluirse una cortada, puede que haya habido puntos o lo que sea.
What is the state's position on bond?
Standard
¿Qué
bond.
piensa la fiscalía de la fianza? Go ahead, state, I'm sorry.
It's okay. 2,500, Your Honor, standard.
2,500, que sería la fianza estándar, señoría.
And Judge, I'm asking for pretrial services with the alternate standard bond.
Señoría, estaría yo pidiendo el servicio previo al juicio y como fianza alternativa la fianza estándar.
Correction says she doesn't qualify because of this charge.
Debido a la índole del cargo, dice el departamento carcelario que ya no califica para este programa.
I will set the standard bond at $2,500.
Entonces se impone la fianza estándar de $2,500.
Which I will now review much more carefully.
La cual ya de hecho he revisado más minuciosamente.
All right.
Muy
If
bien.
she found out, is she living with the alleged victim or does she have a different
En caso de que ella llegue a pagar fianza, ¿vive con la presunta víctima o vive por separado?
I really kind of need to know that for purposes of the stay away order.
Necesito saber eso para fines de la orden de alejamiento.
No, the arrest affidavit, they do have the same address. I'm not sure if, sorry, I didn't mean to interrupt defense counsel, I just can't.
Según el informe del arresto, tienen la misma dirección.
No, I wasn't going to say anything, sorry.
So you're asking for no contact at all.
Correct, Your Honor.
Está pidiendo que no haya ningún contacto en lo absoluto, correcto, así es.
Yes, number 4 needs to be signed on all of them. It's only number 6 when there's a modification to the stay away order.
Okay, if you're gonna return to the residence to retrieve your belongings, you have to ask the police to accompany you.
Entonces, si tiene que regresar a la residencia para sacar sus pertenencias, tendría que pedir a un policía que la acompañe.
Harvey Raimondi.
Judge, my understanding is that Ms. Raimondi refused.
We'll reset 3839. Change the clocks, they're not gonna be happy. Because they're gonna be waking up an hour earlier to transport them
Right.
tomorrow.
They're gonna be even longer.
And Sundays are longer.
Denise Marin Torres Garcia.
Your Honor, Ms. Garcia is out on misdemeanor probation, M2321959.
Okay. I have 2 cases. The first case is 254831. Ms. Torres Garcia, you're charged with grand theft vehicle, resisting an officer without violence to his person. Give me a moment to review. Any argument on probable cause for this?
Judge, I don't have any probable cause arguments for this case ending in 4831, but I do have a probable cause for the case ending in 4847.
Okay, for this case, the court finds probable cause for the grand theft vehicle and resisting the bonds state.
Your Honor, the state would be requesting $5,000 on the first count and $500 on the second count.
No objection.
5,000.
Yes.
Grand theft vehicles, the first degree felony?
Yes, Your Honor.
Since
Yes,
when?
Your Honor.
That-
That's what it
That's
says
a,
here.
that's a great question.
All right, 5,000 and 500.
It depends on the vehicle's value, Your Honor.
This is a Nissan.
Well,
Not to mix Nissan, but it's not like a Lexus, right?
That's fine.
I don't know, Your Honor.
Is it really based on the value of the car?
Well,
I believe so.
a quick search of the statute, yeah.
Is that correct? Defense?
It is a recent change, yes, Judge, and I'm arguing that there is no probable cause for the first degree felony, and that should only be a third degree felony because there's no amount alleged. However, I think the state's probably going to request the same amount, so.
5,000?
Right.
So when did it go to the first degree felony?
I believe, so there's first, second, and third based on the value, and I believe that took effect in January of last year. I think the statute says any amount over 20,000 is the first degree felony.
I don't see where they established the value of this car.
They don't.
So what would it be if it's just a used Nissan Sentra?
I don't know, Your Honor.
I think it's the same bond amount.
First degree felony.
2,500.
All right, I'm going to reduce it to 2,500. They haven't proven me that this Nissan Sentra is worth first degree felony bond.
Okay. I just went based off of what was charged, Your Honor.
They would have to allege value, right?
I know for criminal mischief you do. I'm not sure if you have to allege value for grand theft of a vehicle on the arrest affidavit.
All right, let's get to the next case. I'm sorry. I digress.
No, it's hers again.
Well, not there.
For the first case, there's
a stay away order for the first one?
Yes, because the car was taken from a dealership. Or
America?
a rental car company. I'm
Okay,
sorry.
gonna enter a stay away order prohibiting Miss Torres Garcia from
It should be the LLC state.
America LW LLC at 3995 Northwest 25th Street. Do I have to write stay away order too? Love your acronyms in the criminal court system, you know. SAO could mean state attorney's office.
Oh,
stay away order.
I know.
Right.
It's so confusing.
I was so confused when I first started.
All right. Ms. Torres Garcia's second case is a burglary, unoccupied dwelling, and count 2 trespass. Theft of a vehicle, and then theft of a motor scooter at FIU. Any argument to probable cause?
Yes, Your Honor. As to count 1, there is no probable cause for burglary. There's only probable cause for trespass at best. There is no allegation that Ms. Torres Garcia committed or intended to commit a crime within the dwelling at the time she entered or was inside. And the intent to commit the crime is what elevates a trespass to a burglary. And so if you agree and you agree there's only trespass, there's only probable cause for trespass, then count 2 is duplicative and should only find trespass, probable cause for 1 count of trespass in this whole case.
Your Honor, I understand you don't have to have taken anything for it to be considered
have an
burglary.
intent to commit offense therein, right?
Correct.
So what
and breaking and entering.
What Well, just breaking and entering itself is not, that's trespass. What's the offense to be committed there? I don't see it. This is confusing A form because it starts off with the vehicle was stolen at Dadeland Mall.
Yeah, that. first
So I
part
don't,
is
that throws me
confusing,
off.
But nothing is charged regarding the vehicles, so
And
it's
then-
confusing, but
Then it talks about Mr. Solis seeing two people in his house trespassing, but I don't see where anything was taken from the house. And it says the scooter was taken from FIU, but he's actually not charged with the scooter, so. I tend to agree with the defense here that I only see probable cause for a trespass of a dwelling, which is what? The first degree? I mean, misdemeanor?
a second degree misdemeanor, Your Honor,
That would be,
$150
is
standard bond.
is it the same for a structure as dwelling?
I'm not sure what trespass of a
Trespass to-
dwelling would be.
Isn't trespass to a dwelling first degree misdemeanor?
I'm not sure, Your Honor, but this one is a second degree misdemeanor.
Because there was no one inside the property owner, that's probably why.
But it's he's asking if there's a difference between dwelling or structure.
Oh, usually there's no distinction, Your Honor.
All right, the court finds no probable cause for burglary, probable cause for trespass. On count 2, which the standard bond you said was 150,
Yes, Your Honor.
so 150 on the second case, on the second count.
And there should also be a stay away order.
Yes, and I'm going to enter a stay away order that the defendant has to stay away from Carlos Ciro Solis.
Your Honor, what was the bond for count 1? Did you give a bond?
There's no probable cause, so there's no need for a bond.
Okay, so no PC release outright?
ROR on count 1. Release outright?
Yes.
Okay, release outright on count 1. That's RO. Right?
That's correct, Your Honor.
Stephanie Lynn Burham.
Miss Burham is a fugitive from Monroe County with a $7,500 bond. I'm sorry, $75,000 bond.
75,000?
That's correct.
Okay, ma'am, you're charged with having a controlled substance, suspected methamphetamine, and drug paraphernalia. Any argument to probable cause?
No, Judge, I just asked that you consider that the only methamphetamine she's alleged to have possessed was the residue that was inside of a pipe. She didn't have any baggies or.
I saw that. But she has a fugitive warrant, so.
Right.
Well,
Just for bond purposes, yes.
state,
Your Honor, the state would be requesting a standard bond for both counts, so that's going to be $2,500 on count 1 and $500 on count 2.
right, the court finds probable cause, it's bond at $2,500 count 1 and $500 count 3. Lucia Leal Madero.
Judge, she will need the services of the Spanish interpreter.
Ms. Madero, you are charged with aggravated assault with a deadly weapon and battery.
Señora, usted enfrenta un cargo de agresión física con agravantes, con arma mortífera y con agresión física.
Vince, any arguments?
No, Your Honor, I'm just asking for pretrial services with an alternate bond of $3,000 on count 1 and $1,500 on count 2.
La defensa no tiene argumento para motivo fundado, pero sí está pidiendo excarcelamiento para el servicio previo al juicio, confianza alternativa de $3,000 para el segundo y 1,500, perdón, para el primer cargo y 1,500 para el segundo.
Correction says she doesn't qualify.
El departamento carcelario pregunta, perdón, el juez pregunta si califica para ese servicio.
Standard bond is 2,500 on count 1, is that right? And 500 on 2?
No, Your Honor, standard bond is 5,000 on count 1 and 1,000 on count 2, and I would also be requesting GPS level 3.
I'm sorry, for interpreter, 5,000 on count 1 and how much for the second one, please?
1,000 on count 2.
Got it, thank you. And you're asking for GPS?
GPS level 3.
Let me see.
Got it, thank you, thank you. Entonces, la fiscalía dice, señoría, la fianza para el primer cargo son $5,000, para el segundo son $1,000 y están pidiendo el grillete GPS nivel 3.
Judge, I don't think GPS is appropriate here at all. She's 65 years old. She has no prior arrests.
Señoría, yo no creo que el grillete GPS sea adecuado en este momento. Ya tiene 65 años de edad y no tiene antecedentes penales.
Is she related to the alleged victim?
¿Es ella familiar de la presunta víctima?
Defense?
Judge, according to the arrest affidavit, she is the alleged victim's, let's see, grandmother-in-law, I believe.
She's the grandmother-in-law of the victim, but they reside together as a family, so that qualifies as domestic violence. And I don't think an argument about her age matters when she followed the victim around with a knife.
Señoría, yo no creo que este caso, de hecho, no creo que haga una diferencia el hecho de que tenga más de 65 años. Ellos viven juntos, se trata de la nieta o la esposa del nieto o nieta. Es un caso de violencia intrafamiliar y el caso de que ella lo persiguió con un cuchillo. Me continue, State. I'm sorry, I didn't mean to interrupt, but I had to take notes. I'm sorry.
Okay, I'm going to find probable cause. Said bond at $5,000 count 1, 1,000 on count 2. I'm also entering a stay away order for the alleged victim, Glenda Pineda.
Entonces voy a hallar motivo fundado para el cargo. Le impongo fianza de $5,000 para el primer cargo, $1,000 para el segundo, más le impongo una orden de alejamiento de la presunta víctima de Glenda Pineda. You may continue, Judge. Thank you.
If you live together, you will have to get the escort of a police officer to go to the house to retrieve your belongings until this case resolves.
Si viven juntas, entonces tendría que ir con la policía solamente para que vaya a retirar sus pertenencias.
Shannon Nicole Green.
Bond out, Your Honor.
Oh, I didn't hear. Alexandra Lynn Howard. Yellow card. What does that mean?
Good question.
Why do I have these?
Because we had.
She's in the hospital, Judge. I think we'll need to reset her.
Okay, reset till tomorrow. Same thing from yesterday.
Mm-hmm. Oh, female. It was what's her name? Edith.
Lazero be assigned to the DC. Yellow card back. Is there a red card too? Edith Osak Pamwan. My apologies for the pronunciation. Ma'am, you're charged with child abuse, no great bodily harm. What do you mean? Defense? There's 2 counts.
Yes, Your Honor, I'm just asking that you grant her pretrial services. If she does not qualify, if you can order her in, or give her the alternate bond of $1,500 on each count for a total of $3,000.
Does she qualify? Corrections? She does. State any objection? I don't see any priors.
No,
I have actually the wrong sheet.
Judge, she technically has no priors. However, the reason why she has no priors is because she completed a pretrial intervention for a similar charge, child neglect, great harm, back in 2023. The reason is no priors because she completed the program. However, given that this is another offense with 2 counts, we'll be asking for standard bond for $2,500 on each.
Judge, I'd just like to point out that that case from 2023 was, according to the clerk's filing, 8/12 of 2023, so in August. And this allegation, according to this arrest affidavit, is July 14th of 2023, so it actually predated. So she did not pick up a new offense after doing pretrial intervention.
It's this, Your Honor, this case is for a span of 2 years. This is why it's multiple counts and not just 1 count. Given this, the state's argument still stands that we're requesting standard bond.
Only one of those counts, just to be clear, spans any duration beyond July of 2023.
Your Honor, this took place between July of 2023 and March of 2025, and it happened every time that the victim came from the witness's home. This isn't something that just happened in 2023 and then happened 2 years later.
That's consistent with
It also has to do with the child's genital area. That's concerning.
The victim is a minor?
Let me see the age, Your Honor. Correct. The victim is born in 2016.
And Judge, given the alleged victim's age as it relates to the allegations the state seems to be most concerned about, she would have been ages 7 to 9. I think there may be genuine concerns from a parent that maybe the child is not able or is not willing to describe certain abuse, perhaps from just age and lack of knowledge generally.
Find probable cause. The bond requested by the state was
25 on each count.
25. So count 1.
2,500 and count 2, 2,500 for a total of $5,000, Your Honor.
It'll be $2,500 on each count. And I'm ordering stay away with her. I don't know if they live together or what happened to the child. It's like, it would be helpful if the police officer put that in the name form.
I do believe DCF was contacted according to the A form, Your Honor.
In the event that the victim in the above case is a child, the victim and the defendant are the subject of a separate, is there a dependency case?
I do believe, I'm not 100% certain, but DCF was contacted according to the A form. So possibly going to be one opened.
You're gonna check number 7, because it says that any dependency court orders would supersede this order. Does it seem appropriate?
I'll
I'm
leave-
not familiar, Your Honor.
We'll leave it to Your Honor's discretion.
Because I'm not aware if there are any cases,
Yeah.
and I don't know.
It's just if there is.
Yes.
Okay,
That's fine, Your Honor.
yes, Your Honor.
Clerk is nodding his head.
Yeah.
Exxon Gonzalez Caceres. 2 cases. Mr. Gonzalez Caceres, you have 2 cases. The first case, F254825, you're charged with battery by a detainee on another detainee at TGK yesterday at 7:23. Court finds probable cause. Is the bond in that state?
Your Honor, I'm sorry, the state would be requesting. The state would be requesting 2,500 on count 1.
There's only 1 count.
We're on the
Oh, I'm sorry, Your Honor. The state would be requesting 2,500.
The next case, and counsel, I'll let you address the bond after both cases. The next case, Mr. Gonzalez Caceres, is 4768. You are charged with possession of a controlled substance, methamphetamine, possession of drug paraphernalia with intent to use, battery. Arguments to PC,
No, Your Honor.
the bond on those cases, those charges.
Your Honor, the state would be requesting 2,500 on count 1, 500 on count 2, 1,000 on count 3, and a stay away order.
No objection.
All right, so back to the first case, the bond is $2,500 in count 1. For the second case, probable cause. $2,500 on count 1, $500 on 2, $1,000 in count 3. And there's going to be a stay away order. You are to stay away from the alleged victim. His initials are Ms. Elmira Caceres. Luis Humberto Lopez.
Mr. Lopez is out on felony bond F 23 015 028.
Mr. Lopez, you're charged with possession of controlled substance, methamphetamine, possession of controlled substance, gamma hydroxyl butyric acid, identification, possession of a fraudulent ID, possession of drug paraphernalia. Court will take a look at the arrest affidavit for probable cause. Argument to probable cause.
I have no arguments, Judge.
Okay. State. Bond issues.
The state would be requesting a felony hold on F 23015028.
That'll be granted.
And as to the present case, the state would be requesting 2,500 on count 1, 2,500 on count 2, 2,500 on count 3, 2,500 on count 4, 2,500 on count 5, 2,500 on count 6, and 500 on count 7 for a total of $15,500.
Oh, well, I've messed up here. I'm sorry. I didn't realize there's 4 counts of fraudulent ID.
Correct, Your Honor.
So you're asking for
The standard bond on each count
On
is
each-
2,500.
And Judge, I'm just asking,
yeah.
That's $500. Standard bond.
All right, let me hear from the defense on the bond.
I'd just be asking for a slightly lower bond on each of the 6 counts, if you could do 1,500 instead of 2,500.
The court has concerns about the ensuring that the defendant will appear for court because it says he is homeless and he has allegedly three false IDs on his possession when he was arrested. So count 1 will be the $2,500, count 2, $2,500. There's 4 counts of fraudulent ID. So you're saying you want $2,500 for each ID? Is that
Correct, Your Honor. That's standard bond.
so? That would be counts 4, 5, 6, and 7. Is that right?
No, Your
No.
Honor, it'd be
3,
3, 4, 5, 6.
3, 4, 5, 6.
That would be a total of 10,000 between those 4 counts.
Okay. So it'll be $2,500 for counts 3, 4, 5, and 6. Count 7 is the misdemeanor, right?
Correct, Your Honor.
So that would be $500. And again, there's the felony hold. Willie Lee. Good afternoon, Mr. Lee. You're charged with possession of controlled substance, crack cocaine, drug paraphernalia. Did we already address the DWLS?
I think we did in the morning.
Okay.
We did, Your Honor. You gave him $500 bond.
Defense, anything?
Judge, I have no probable cause arguments. I'm just asking for pretrial services with an alternate $2,500 bond on count 1 and $500 on count 2.
Any priors, state?
He does have some priors, some older ones, Your Honor. He does have a cocaine possession from 2004, cocaine possession from 2015, drug paraphernalia possession from 2015.
Was he qualified for pretrial services? Yes.
Judge, the only thing is we've already given him a bond for the DWS, so he'd have to pay that anyways. At this point, we'd just be asking for standard bond of $2,500 for count 1, $500 for count 2.
And Judge, there's no harm in giving him the alternative if he's able to get pretrial services.
Really, I hear you.
Sorry, there's no harm in giving him the pretrial services as an alternative. We have no idea what's going to happen with his DWLS case. It may be dismissed. He may get a bond or a lower bond, or he may be released.
I'm gonna give him pretrial services with the alternate bond.
2,500 count 1, 500 count 2.
Yes, 2,500, so a total of 3. 2,500 count 1, 500 count 2. Rainier Rodriguez. Mr. Rodriguez, you're charged with possession of
Rodriguez, Your Honor, is a bond out.
bond out?
Yes.
Lazero Compost. Mr. Compost, you're charged with possession of cocaine. Did we already address the DWLS? I assume?
I think so, Your Honor,
Okay.
because it's not on this calendar.
And the court finds probable cause for the possession of cocaine. Does he qualify for pretrial services? Okay. Lots of priors. What's your position on bond?
Your Honor, the state would be requesting standard bond of 2,500.
Okay,
No objection.
standard bond 2,500. Ruben Rodriguez. Mr. Rodriguez, you're charged with possession of cocaine and drug paraphernalia.
Judge, I also believe he was out on felony bond.
For a 2020 case?
Correct.
The court finds probable cause. What's your recommendation as to bond on this?
Recommendation is, actually, do you need the case number for the other felony, the one he was out on bond, or?
This case, the cocaine and.
For this one, Your Honor, we could do standard 2,500 count 1 cocaine, 500 for count 2, the drug paraphernalia, and a hold on case F208803.
No objection to standard bond.
Bond will be 2,500 on 1 and 500. Count 2 with the felony bond on the 2020 case. Felony bond hold. Peter Panayotto.
Just a moment, Judge. He's coming. He's in a wheelchair.
Not to make light of it, but it says that he walked out the front door. Was he injured?
I don't believe so, Judge.
Sorry, I mispronounced your name. It's Ana Yoto. You're charged with possession of controlled substance, methamphetamine, commonly known as ecstasy or Molly, and also possession of marijuana.
And Judge, there's 19 counts of the
Oh, I see.
And Judge, I do have a probable cause argument as well.
Let me read the arrest affidavit. All right, what's your argument?
So Judge, as to count one, I'm arguing no probable cause because he's found to be in possession of a bag with various colored pills. The officers state the pills appeared to be ecstasy, but they don't state anything else. They don't say why they suspect that, whether they've encountered similar pills. There's no field testing that's conducted. And it's just as likely that the pills they described could be children's multivitamins for all we know. And additionally, if Your Honor is inclined to find probable cause, you should only be setting bond on count one, as the appropriate charging unit for this type of charge is the type of substance, not per pill.
State.
Your Honor, just,
We'll first address the substance.
Yes.
How do we know that it's suspect ecstasy?
I will say that.
That of children's
The defendant-
vitamin named, what was it? Laughing pills.
Well, I think that's something that would have to be argued after first appearance, for field testing to have time to be done, for the officer to speak to their experience. If they want to have a PC hearing, that can happen. Also, the defendant spontaneously stated that he took an ecstasy pill the day prior. I also would object to, I mean, I'm just not, it's within your discretion what you want to do, but I'm not going to stipulate to just dismiss 18 counts on first appearance.
And I'm not asking the state to dismiss. I'm just, he should be released on his own recognizance, or he should be released outright on those counts. But as it relates to the ecstasy argument, it seems more likely that he stated something about took an ecstasy pill yesterday, and then they just assumed that that's what he had based on that statement, but we don't know anything.
Is there anything significant in his history that I need to see?
He does have a number of drug-related priors, Your Honor.
It looks like everything is misdemeanors, right?
Correct.
And when the state says drug-related priors, they mean cannabis, which really isn't a drug.
Well, there's also a contained substance, FO7, that is a felony. It was no accident, but it is on the priors.
We're gonna find no probable cause for the 19 counts.
There are also other priors from other counties. I don't know if you would like to hear those, Your Honor.
I'll find probable cause on the marijuana. What's the bond on that?
For that charge, Your Honor, it would just be $150.
All right, $150.
Your Honor, count 1 through 19 will be released outright, correct?
Release outright counts 1 through 19.
Thank you.
Thank you. Ernesto Perez.
Mr. Perez, Your Honor, is out on probation, F2411523.
Mr. Perez, you're charged with unlawful sex activity with a minor.
Mr. Clerk.
10 counts. Dependent, anything?
Judge, I don't have any probable cause arguments. I'm asking, however, that you give him a bond of $2,500 for each count. And I don't believe there should be a felony hold because it appears that these allegations occurred before he took probation. He took probation on February 7th of 2025, which was just last month. And the arrest affidavit indicates that all of the incidents occurred while he was on house arrest. And as of February 7th, 2025, he is no longer on house arrest. So it corroborates that there should be no felony hold because his probation, he took probation after the allegations were alleged to have occurred.
If it occurred before he was.
First address the bond, and then we can talk about the felony hold.
Correct. The state would be requesting 2,500 for each of the 10 counts. So,
okay.
Yeah, $25,000 would be the total.
All right, so the court finds probable cause. Set bond at $25,000 for counts 1 through 10.
$25,000 in total, Your Honor, or each?
Correct. 2,500 per count, 25,000 total.
Thank you.
All right, then tell me about the felony probation case, because they're saying all of this occurred, this predates his probation case, so.
But Your Honor, if it predates it, there should be no hold placed because he didn't violate his probation based on it.
Okay. So no hold. There's gonna be a stay away order. You're not to have any contact with the alleged victim in this case. His initials are AD. Ruben Wall. Is Mr. Wall here?
It's coming up, Your Honor.
Mr. Wall, you're charged with lewd and lascivious exhibition on a child between 16 and 18 and indecent exposure.
Judge, I do have a probable cause argument.
Let me finish reading the narrative. I see what the argument is. So state, can you respond?
Yes, Your Honor. I'll argue that I know what
the
the
restroom.
argument's gonna be.
He's not.
He's urinating in a restroom.
He's not in the restroom, Your Honor. He's in the
That's what it says.
He's in the hallway.
He's in a public hallway leading to.
Oh, okay. I'm sorry. That says leading to the bathroom. I got it.
Right. Now, I'm assuming defense argument is going to be that he was just urinating. However, he continued to urinate. He never stopped. He stared at them, and then he continued to urinate, which would.
Well, why does it make it a lewd and lascivious?
Because the behavior of him continuing to do it.
In the public hallway
Right.
in the airport.
Hold on. Let's pull this down.
Judge, yeah, it's not lewd and lascivious. I don't recall all of the,
25,000 total.
I don't recall all of the definitions of lewd and lascivious, but it's
I'm sorry. I'm sorry. Can you just give me 1 minute?
Yes, sorry.
Eight 800.04 7A B. So lewd and lascivious manner.
Judge, the urinating itself, he's exposing himself in a vulgar or indecent manner. That's part of the statute. I mean, it's
He has his private parts out in a public hallway in an airport. He sees them staring at him and he continues to do what he's doing. I mean, and the statute only says 7A2 intentionally exposes the genitals in a lewd or lascivious manner, which I think based on the four corners of the A form, there's probable cause for, at least to that standard.
And judge, that there just is no lewd and lascivious. Like, the definition of lewd and lascivious is unchaste. It's in a sexual manner. It's to promote sexual gratification. I believe those are the actual definitions per the statute. What the state is describing and what the allegations make out is indecent exposure, with which he's charged in count 2.
Just reading from the statute of lewd or lascivious exhibition.
If you find the definition of what is lewd and lascivious, it tells you it's unchaste, for sexual gratification. It's something that is done for sexual gratification. There has to be, in other words, if he had looked at them and then touched his genitalia or masturbated in some way, then I would agree that is lewd and lascivious.
During the time.
I mean, for purposes of probable cause, I can't say if that brought him any sexual gratification. Again, that I think that would be for something that comes up later, and not for purposes of meeting.
It's an objective standard. It's not a subjective of whatever intended. What about his history? Is there anything in his history that causes concern for the state?
No, Your Honor. However, based on the fact that this was 2 minors, one fitting a felony in the 2nd degree and one just barely missing it, we would be asking for bond for this case.
Well, I'm definitely finding probable cause for count 2.
One, and you're not finding probable cause for count 1?
No, I'm not. I'm not finding probable cause. I'm releasing him outright on count 1. No PC on count 1.
I would request this be reset for a PC hearing, and then we can call the officer in.
What's the defendant's position on that?
Judge, my position is that there is no need for a probable cause hearing. The only allegations are that he committed an indecent exposure, and that I don't know what facts would suddenly come to light to support this charge. The state is relying just on the fact that he didn't attempt to conceal his penis from these minors, but that is the very definition of indecent exposure. There's nothing that indicates.
I've already agreed with you on that. So what's the standard bond in count 2?
The standard's 1,000, but in light of Your Honor finding no probable cause for count 1, we would ask for elevated bond in the amount of $5,000, considering it was a minor, 17 years old. And it's up to Your Honor's discretion. However, that's going to be our ask.
Judge, I would object to an elevated bond that the state is essentially seeking to punish him for the fact that an officer mischarged him and you properly found no probable cause.
Set bond like $1,000 in count 2. Just stay away order.
Correct, Your Honor. One for each victim.
I'm gonna enter a stay away order for the 2 minors. MS. They're both MS. I don't know.
Their names are on the second page, Your Honor.
So he said to have no contact with the 2 minors who were at the scene. Eric Miguel de Casada da Silva.
And he does need the services of the Spanish interpreter.
So you're charged with grand theft vehicle, possession of a vehicle with an altered ID, misusing a temporary tag, failure to have vehicle registration.
Señor, enfrenta el cargo de hurto mayor de un vehículo, tenencia de una chapa o placa alterada, uso inadecuado de una chapa o placa, perdón, y no tener la registración o matrícula del vehículo.
That's fine, probable cause.
El juez haya motivo fundado para el cargo.
Sí.
Judge, I just asked for count 3. I don't believe there's any probable cause. It seems just an extra count of possession of a vehicle with an altered VIN. There's only allegations that he possessed 1 vehicle.
La defensa dice que no hay motivo fundado para el tercer número, para el cargo número 3, perdón.
State. This is count 3.
Stipulate, Your Honor.
So no PC on count 3. And bond.
On count 1, Your Honor, $5,000. On count 2, $2,500.
So now we have a Corvette Stingray. You're saying that the Corvette Stingray is felony 1.
It was charged F1 both times. On count 2, we would
I'm supposed to take judicial notice. A Corvette Stingray is maybe an $80,000 car.
Quiero tomar nota judicial de que ese tipo de Corvette Stingray tal vez es un carro evaluado en $80,000 y el juez dice para el primer cargo la fianza son $5,000, para el segundo cargo son $2,500.
That's why that makes it the first degree felony, right? The value.
El valor del carro constituye este delito en un delito grave de primer grado.
Judge, I'm asking that you only find probable cause for the 3rd degree grand theft of the vehicle because there is no amount alleged. It doesn't even give us a year for the Corvette Stingray for you to take judicial notice.
Señoría, quiero solamente que tome nota judicial de que el informe del arresto no incluye el valor o la cuantía del vehículo ni el año, entonces simplemente que halle que este es un delito grave en tercer grado.
Although I do recognize that if it were really old, it would probably be much more than 80,000.
Aunque soy consciente de que si el carro fuese más viejo, incluso estaría evaluado en mucho más de $80,000.
Or if it was brand new. Either way.
O si está nuevo.
What is the 3rd degree felony bond?
$2,500, Your Honor.
Pues quiere confirmar cuánto es la fianza de un delito grave en tercer grado, son $2,500.
Is it $2,500 count 2?
Yes, Your Honor.
All right. Count 3, no PC, release outright. Count 4.
I think you already addressed the
Wait,
remaining.
I think. Okay.
Yeah.
We already addressed that this morning, right?
Right, I believe it was 150 each.
Entonces, el caso del cargo número 4 ya fue abordado esta mañana. Para el cargo número 3 no hay motivo fundado. Para eso se le da un excarcelamiento directo y ya se abordó la fianza de los primeros dos.
Okay, so just to clarify, Your Honor, was that count 1, 2,500 and count 2, 2,500?
Correct. Thank you.
Entonces son 2.500 para el primer cargo y 2.500 para el segundo.
Nelson Jorge Barra Bravo. Do you speak English?
He does, yeah.
Okay. Mr. Barra Bravo, you're charged with an aggravated battery.
Yeah, but,
Judge, I do have probable cause argument.
Okay, let me just read the narrative. What's your argument?
Judge, there is no indication that he backed into the alleged victim intentionally. Mr. Para Bravo is 78 years old, and if you'll notice, the incident location is right next door to his house. So it's not strange at all for him to be parked off the roadway. He could be parked in his own, right next to his own driveway. The allegations don't support any malicious or nefarious intent. It honestly sounds more like an accident, and the witness did not indicate that he observed any intentional action on Mr. Para Bravo's behalf. He never told the officers that he saw anything to indicate Mr. Para Bravo acted intentionally. He just says that he saw him back into the alleged victim's car with his car. Similarly, I know the state doesn't have to prove a motive, but I think it's worth considering that there is no motive alleged for him to just back into somebody's car. There's no malice or issues between these two that are mentioned in the arrest affidavit.
It does say that he purposely and intentionally backed up his vehicle to the victim's driver's side.
And that is from the alleged victim, I suppose, but it doesn't say why she believes that. Just
Going off the four corners of the A form, there is probable cause. That would be an argument to be made later on in the case.
What it doesn't say is the victim was inside the car at the time, does it?
The victim was inside her car.
But does it say it when she backed up?
The defendant backed up and the victim was driving.
Because when you saw her vehicle, he placed his vehicle in an angle and proceeded to purposely and intentionally backed up his vehicle to the victim's driver's side and struck the driver's side of victim's vehicle.
In the beginning, it says
But it doesn't say she was in the car at the time he was struck.
who advised that she was coming home from work and was driving home.
But it doesn't say she was struck. She was in the car at the time he was struck.
It was on the road. I mean, she didn't just leave her car in the middle of the road, I would assume.
And Judge, it's not clear whether she's referring to, if she was inside of a car, it's not clear that she was inside of the car that was struck. She could have been driving down the road, seen a car that she had parked in her driveway and saw him back into that car. Additionally, there's no indication that
Foreman was coming up with hypotheticals.
there's no indication that she.
Release outright.
Thank you.
Craig Alexander de los Santos.
That's a bond out, Your Honor.
Okay.
You were muted before.
Robert John Hermanson.
Yes, sir.
Mr. Hermanson is out on felony bond F25-4216.
You have two cases, Mr. Hermanson. The first one is petty theft with prior convictions of marshals on Miami Beach. Second case is petty theft, prior conviction, retail theft, I'm sorry. Guess this is the same marshals
Yes, appears so.
on September 17th.
And Judge, I do have a probable cause argument as to the second case. I'm not sure if you want to hear that now. It's just as to the charge.
Let's take the first case, which was on top, was 254820. No argument to probable cause. The court finds probable cause.
$500 bond, Your Honor.
Bond set at $2,500.
And we'll be requesting a hold on the felony bonds.
Do you know what the charges are in that case?
In that case, it's controlled substance with intent to sell or deliver, loitering or prowling, drug paraphernalia possession, and resisting an officer without violence.
There'll be a hold on the other felony case. In the second case, counsel, you had an argument as to probable cause?
Yes, Your Honor. So I'm arguing that in this case, there's probable cause only for a third-degree felony retail theft because Florida statute 812.0159A states that the prior conviction must have been specifically for retail theft, which is not the case here. In other words, he can't be charged with retail theft with prior conviction if the prior conviction was only for a petty theft, which the only prior convictions that Mr. Hermanson has are for petty theft, not retail theft.
Let me just look through his priors, see if there was any previous retail theft. Doesn't look like he has a conviction for retail theft, so we'll stipulate to only being third degree felony. We'd be asking for $2,500.
Okay, so bond would be set at $2,500. PC for what is the charge then?
It's just retail theft, which I believe it has to be over $750 or over 300. Counsel, I think you're more.
PC for retail theft, but there's prior convictions.
There is no prior conviction, Your Honor. That's all.
But what makes it the third degree felony instead of a misdemeanor?
One in the event, it wouldn't be a misdemeanor because he has previous theft convictions, Your Honor. So it'd be at the very least petty theft, 2 or more convictions.
Okay.
So either way, it would be a third degree felony.
And I'm gonna enter stay away order, Mr. Hermanson, here to stay away from the Marshall 723 Lincoln Road in Miami Beach.
You're on a case ending in 39 is 2,500 as well?
I'm sorry, I didn't.
Yes, you put 2,500 on the case.
Yes, 2,500.
Thank you.
Reynald Perez. Mr. Perez coming?
He is, Judge. He's in a wheelchair, so it's taking him a second.
Thank you. Mr. Perez, you have two cases. The first case, you're charged with possession of cocaine, possession with intent to sell, tampering with evidence, and possession of drug paraphernalia. Is there any argument to probable cause defense?
Judge, my only argument is that as to count 1 and 2, there should only be one count of the possession of cocaine. Not two.
Count 1, they have 2 counts.
I'm not understanding. Is she arguing PC on the 2 counts of the cocaine
Yes.
possession, or is she arguing cocaine possession versus cocaine possession with intent?
No,
to sell?
I think she's saying there should only be 1 count of possession.
So I'll concede that there's PC for count 1, possession of cocaine, and that there's PC for possession with intent to sell, but there should not be 2 counts of possession of cocaine. So counts 1 and 2 are duplicitous.
Actually, the term is duplicative. Duplicitous is a word that has a totally different meaning. Duplicitous means deceptive or deceitful.
Oh.
Means duplicative, it's double.
I did not know that. Thank you.
It's a frequently misused word. And I think attorney this morning or actually used this incorrectly as well. So, duplicitous.
Judge will
Word of the day.
will stipulate to only 1 count. There's only 1 count.
Okay, so there's PC for 1 count. What is the bond on that?
2,500.
2,500 bond on the next one, possession with intent. She stipulated to PC.
5,000.
5,000. Tampering with evidence is at 2,500.
Yes, it's the 3rd degree.
And paraphernalia.
1,000, Your Honor. To miss first degree. Oh, 500. Sorry, Your Honor. 500.
Your drug paraphernalia.
Okay, so corrections, did you get that? Count 1, $2,500. I guess count 2, there's no PC, so released outright. Count 3 would be $5,000. Count 4 is $2,500. And count 5 is $500.
Thank you, Your Honor.
Now, the next case you have, Mr. Perez, is petty theft with 2 prior convictions. This alleges that you took property of Whole Foods, 4 bottles of wine. Any argument to PC?
Judge, I just think that maybe retail theft would be the more appropriate charge here, given that he stole from, or he's alleged to have stolen from a retail establishment on a few different dates, rather than 4 different counts of petty theft.
Your Honor, they're both 3rd degree felonies.
I think the felony attorney can make the filing decision.
The filing decision can be
So
left
they-
for the felony attorney. Bond,
Well, shouldn't it? Why is it 4 counts?
because there are 4 occasions that he walked in and out of the store.
Oh, 4 occasions, I thought it was 4 bottles of wine.
No,
No,
Your Honor.
it describes each count in the arrest affidavit, and you can see at what time the defendant
The
entered the
same,
store each time.
different dates.
Correct.
Yes, two are on the same date at different hours, at 4 hours apart.
And the retail theft, that count or that charge is specifically designed for something like this, where he enters or a person enters on multiple occasions, takes things, and then the aggregate together is in the retail theft range.
What is the bond you're asking for?
It would be the same for either one.
That's
So
what I thought.
the formal charge can be left up to the felony attorney. We would be asking for 2,500 on each count.
Judge, just to be clear, the reason I'm asking is because there's 4 counts of petty theft with a bond of $2,500 each, where if you were to find probable cause for 1 count of retail theft, you can set bond at $5,000 instead of an ultimate aggregated bond of $10,000.
Well, the standard bond is just a suggested bond. I can still find probable cause and set the bond at 5,000. Correct?
You could, yes. I think it's a more appropriate charge for the different dates, but
I know, but as the state said,
There's
they
still,
can make the decision as to what to charge you
and
with.
Judge, there's still probable cause for the petty theft 2 or more convictions, given he has more than 2 convictions. And therefore, for that reason, we'd be asking for 2,500 for each.
I'd be asking for 1,000 each.
I'm gonna find probable cause, but I'm gonna set the bond at $1,000 each. So
So $4,000 total.
total. Did this defendant have a felony hold or was that?
No, Your Honor.
But I'm gonna enter a stay away order for Mr. Perez cannot go to the Whole Foods at 299 Southeast 3rd Avenue in Miami until another judge dissolves this stay away order.
The defendant does have an open misdemeanor case for, again, petty theft.
He was given $1,500 bond on that.
Okay. Frank Luis Yanes. Yanes, you're charged with possession of a controlled substance, suspected crystal meth. The court finds probable cause and this defendant has an argument.
No, Judge, no arguments, and we'll have no objection to standard bond.
Does he qualify for pretrial release? State, any objection to
No
pretrial
objection.
services?
No objection with an alternate of 2,500, Your Honor.
Okay. EC pretrial services with an alternate bond of $2,500. Melvin Robinson.
Mr. Robinson, Your Honor, is the VFOC. His probation case is F23024-646, and he's been held no bond on that.
Okay. Mr. Robinson, on this case, you're charged with, I guess, failing to meet the requirements of sexual offender registration. Is there any argument from defense?
No, that's a probable cause.
What? There's 2 counts, so where do the 2 counts come from?
It's from a new case, Your Honor. F254-823, which is the same charges, two counts of the same charge.
Okay, so there's PC and the bond is.
Your Honor, we'd be asking for a felony probation hold on F23024-646. And then,
I know.
regarding,
He's already been held, no bond on that case.
I'm asking you what's on this case, then we can get to the other case.
regarding this case, the state would be requesting $2,500 on count 1 and $2,500 on count 2.
Okay, it'll be $2,500, counts 1 and 2,500 2.
Okay. Then, no hold necessary, I guess.
Thank you.
Okay, so that's it.
Yep.
Jeffrey Domingo Perez.
These are added charges, Your Honor.
Good afternoon, Your Honor.
Good afternoon. I'm sorry, corrections, you said something I couldn't hear.
These are added charges.
Thank you. Mr. Perez, you're charged with the felony criminal mischief.
Judge, I have probable cause arguments as to each of the 3 cases.
And there's 3 cases of felony criminal mischief. Okay.
Your Honor, he has a new misdemeanor case. It'll be on the misdemeanor calendar in the morning. It was another added charge.
Okay. All right, so this alleges that he tagged property, the Blue Sky building on Miami Beach. The second one is at the Rue Notre Dame roadway. And the last one was the 1250 Normandy Drive. Defendant, you said you had argument as to probable cause.
Yes, I have probable cause arguments, the same argument for each case. So he was arrested originally because an officer observed him tagging a building. However, so then after that, then every time they found the same tag, then they just added a charge on him. So my argument as to these 3 cases is that no one observed Mr. Perez doing this graffiti. The officers are just assuming that it was him because they've seen him graffiti the same word, but that does not establish probable cause. Anyone could have spray painted the word EMIC or EMIC 1. The officers don't say what that means. There's no indication that Mr. Perez is the only one who writes it. It's akin to if I were to spray paint a smiley face on the side of a building, an officer sees me, I get arrested for it, and then every smiley face he sees after that, he's going to add that charge on me, even though no one saw me do it.
So it just sounds like a great argument for trial. However, the probable cause in this case is that he allegedly committed criminal mischief, and by tagging these buildings,
not with a smiley face, but with, you know, a word.
and a variant, there's
Specific to him that he was seen doing. That's, and it has the estimated damage on it, on each A form. I believe based on the 4 corners of the A form, there is probable cause, which is a far lower standard than it will be, you know, going forward. And there's probable cause to arrest the defendant for the graffiti that he sprayed on these.
And Judge, the state represented that this is unique to him, but it's not. There's no indication that it's unique to him. And there's no indication that he's the only person who has ever been seen graffitiing or tagging this word. It's not his name. It's not his social security number that he's tagging. So there's really nothing that's unique to him.
Well, I guess the officers determined that this is really his calling card signature tag. And that's the theory they're operating under, and court finds that that's sufficient probable cause. But what about the bond?
Your Honor, are we doing one case at a time or do you want me to tell you all three right now? They're all the same.
They're all the same, right?
Yes, 2,500 for each count, which each count is a separate case.
So talk to me about the bond defense.
Judge, I'd be asking for a $500 bond on each case. I think these cases are extremely weak. At best, it's maybe Williams rule evidence for use in the other case that they have where an officer observed him, but there's simply not, there's no legs for these cases to stand on. So I'd ask for a $500 bond.
Have any open?
No, Your Honor.
Yes, you're gonna see him tomorrow, Your Honor. It's a misdemeanor criminal mischief that has 1, 2, 3, 4, 5, 6 counts.
The bond has just not been addressed on it yet.
Right.
So on the felony bond hearings tomorrow?
On the misdemeanor tomorrow, which I think you're the judge for, so you'll probably see him again tomorrow.
Does he qualify for pretrial services?
Your Honor, on his B25-004533, he was all hard on that.
Oh, correction, didn't you say there's added charges to misdemeanors?
He hasn't had a charge, it was B254621,
Oh.
but he had a previous misdemeanor case that he was seen on, which is B25-0045-33137, and they ROR'd him on that.
Does it change his eligibility?
Judge Reeves still asking for the standard bond. Given the fact that it's not just one time, we're talking about multiple times, multiple counts. It's not a one-time thing that he just did and that's it.
And I mean, the damage is more than.
And Judge, the practical effect of you finding probable cause, and if you set a standard bond, he's every single day probably going to get a new, every time they see the word somewhere, he's going to get an added charge and he's going to have an endless number of charges and he's never going to be able to bond out.
Yeah, the problem is.
That's beyond the four corners of the eight.
Yeah, but the problem is it doesn't really say when it happened. There's like.
I mean, it happened
That's
on, on March 6th.
So that's when they just
On March.
discovered it. I think he was
But it says today.
observed in the act on one case, right? Allegedly.
The day before. correct.
Allegedly.
And I agree that there is probable cause for that case where the officers observed it.
The pretrial release will take them. I'll confirm the pretrial services. Alternate bond is going to be the standard bond on each case. $2,500. Richard Isaac. Mr. Isaac, you're charged with carrying a concealed firearm.
Your Honor, we do have a motion for pretrial detention.
Well, no, not for this case.
Oh, sorry, my mistake. I thought this was.
We're in I-
Oh, I didn't. Sorry, I'm not big.
Judge, do you have a probable cause argument?
Read it again. All right, probable cause argument?
Yes, Your Honor, the arrest affidavit never states where the firearm was located or where or how it was concealed, and the arrest affidavit actually never even states that the firearm was concealed.
Okay,
I think we can make a reasonable assumption that it was on his person, and then he's being charged with carrying a concealed firearm without proper documents. He doesn't meet the criteria to carry a concealed carry, which is what he's being charged with. I think we can make a reasonable assumption that it was on him at the time.
Judge, if he was arrested just walking down the street, I think that we could make that assumption, but he's in his car and you can carry a firearm in your vehicle without it being concealed.
it really is a dearth of information in this arrest affidavit. I agree. It doesn't say where the gun was or how it was concealed, so no probable cause, release outright.
Thank you.
Was that previous? Okay. Barry Maurice McCrary. 10.
Yes, and
Cases?
now, Your Honor, we do have a motion for pretrial detention.
Your Honor, for McCray Carey, he was relocated to pretrial detention, so we have to reset him for tomorrow.
That's right. He told us that in the morning
Yeah, he relocated to pretrial.
when he has a misdemeanor.
Do I have to write on them all, reset 10 times?
Yeah, they're free set for tomorrow.
When are you guys gonna get in the digital age? It's like,
I disagree.
this is paper. Nobody does this anymore.
Yeah, then they have to redo it.
Reset. Enriquelo Figueroa Rion. Sir, you're charged with felony criminal mischief and battery. Court finds probable cause.
And Judge, just as to count one, there's only probable cause for second-degree criminal mischief because the arrest affidavit never provides an amount or a value for the items that Mr. Figueroa Grullon allegedly broke, and we're not at liberty to guess or make assumptions. There's no mention of the officer observing the extent of the damage on the items themselves.
What's your position, State?
To be honest, Your Honor, I mean, did you hear what she said?
I think she said something of value, that there was no value. I mean, Judge, we'll make the argument that a laptop most is worth more than $1,000. I mean, there's no exact number, but it could be inferred through the A form.
Yeah, it does. I mean, it states what was broken.
An iPhone, a watch, and Apple Watch, and a computer.
Those are $1,000.
Those are kind of expensive these
And
days.
it's only charge one count, which means that they combine 3 items.
Yeah, I find probable cause. What are you going to do about the bond date?
For this one, Your Honor, the state would be requesting 2,500 on count 1 and 1,000 on count 2. And a stay away order.
Bond will be $2,500 count 1, 1,000 on count 2. Stay away order, entering a stay away order. Ms. Angelica Hernandez, sure you to have no contact with her, the pendency of this case, unless another judge dismisses this order or somehow amends or rescinds it.
Judge, Mr. Gonzalez will need a Spanish interpreter.
Present.
Freddy Gonzalez Perez.
Señor González Pérez.
Perez, you have 2 cases. The first case is you're charged with burglary of an occupied dwelling and petty theft.
Señor, el enfrentados cargos, uno es por ingreso ilícito a una vivienda o allanamiento de morada y hurto menor.
Court finds probable cause. Is there any argument from the defense?
Hay motivo fundado para el cargo. El juez quiere saber si la defensa tiene algo que decir.
No probable cause arguments.
No hay argumento para motivo fundado.
State, what's the bond?
Your Honor, the state would be requesting 10,000 on count 1, $150 on count 2, and 5,000 on count 3.
I'm sorry, stay one more time, please, for the interpreter, please.
Oh, sorry, Your Honor, there are 2 cases. So just for count 1, burglary occupied dwelling, the state would be requesting 5,000, and on count 2, petty theft, the state would be requesting $150.
Señoría, estamos pidiendo para el primer cargo, que es allanamiento de morada ocupada, $5,000, y para el segundo, 150.
Okay, 5,000 count 1, 150 on count 2.
Entonces, 5,000 para el primero, 150 para el segundo.
And a hold for division 17. I guess he's out on bond on another case. Is that right?
Y esperar para la edición 17. Tengo entendido había salido bajo fianza por otro cargo.
2 cases.
2 cases, Your Honor.
Son 2 cargos.
F25-224 and F25-2260.
Uno del 24 y otro del 25.
Second case, Mr. Gonzalez Perez, you're charged with grand theft of a vehicle.
Señor González, en el segundo cargo, usted enfrenta un cargo por el hurto mayor de un vehículo.
A 2017 Porsche Macan.
Es un Porsche del 2017.
Any argument to probable cause?
No arguments, Your Honor.
No argumento para motivo fundado.
Bond, 5,000?
That's what the state would be requesting, Your Honor.
5,000.
$5,000 de fianza.
James Howard? Mr. Howard, you're charged with possession of cocaine, tampering with evidence, and possession of crack with intent to sell.
Sorry, Your Honor, hold on, this is not.
He refused. Mr.
Okay,
Howard
Mr. Howard refused. Just like-
I was still no crack.
Okay, Mr. Howard refused reset till tomorrow. Brian Carol Ritz or Ritzy?
Refuse, Your Honor, reset for tomorrow.
Let's see the end. Is it reset? We had a lot of refusals, so
Oh, good.
Neither are we.
Andrew Soto,
Your Honor, Mr. Soto is a fugitive from St. Lucie with the no bond.
all right, Mr. Soto, you're charged in this case with domestic battery by strangulation, aggravated assault, and domestic battery. Is there any argument as to probable cause? Because the court finds probable cause.
No argument as to probable cause, Your Honor. It just ask for 5,000 on count 1, 5,000 on count 2, and 1,500 or 1,000 on count 3.
State,
I couldn't hear what she
she
said.
said 5,000 on 1, 5,000 on 2, and 1,000 on 3.
Correct, Your Honor.
Okay.
And a stay away order.
Okay, I'm going to enter an order, Mr. Soto, that you have no contact at all with the alleged victim in this case. Is there a name? Her initials are IT. Your bond will be 5,000, 5,000, and 1,000, which totals $11,000. But you have a felony hold from another case, another county.
The felony hold is only for the other county, correct? Because this was an added charge and it shouldn't cause a felony hold in Miami-Dade.
No, that's in St. Lucie. The fugitive hold, he has the fugitive hold from St. Lucie County, no bond.
You can just leave whatever we didn't use. If they come back tomorrow, they can just.
Yep.
I'm gonna bring it.
Recycle your paper clips.
All right, everyone, have a good weekend.
See you tomorrow, maybe.
All finished, Judge?
Thank you.
Pleasure. Welcome. You'll have a good weekend now.